Good morning. Can I welcome everyone to this, the 26th meeting of the Justice Committee in 2013. Can I ask everyone to switch off mobile phones and other electronic devices completely as they interfere with the broadcasting system, even when switched to silent. No apologies have been received. Item 1, a decision on taking business in private. I'm inviting the committee to agree to consider a draft Stage 1 report on the Tribunal Scotland Bill under item 6 today and at future meetings in private. Are you agreed? Agreed. Thank you. Item 2, Criminal Justice Bill. It's our second evidence session on the Criminal Justice Bill at Stage 1. 2 panels of witnesses today. We're considering Part 1 of the Bill on arrest and custody with both panels. In addition, we'll also be exploring the establishment of the Police Negotiating Board for Scotland with the first panel. That's Part 6, Chapter 2 of the Bill. And I welcome to the meeting our first panel. I see some other people with season tickets here. I begin to see, or I won't call you the usual suspects, though it might be appropriate in the circumstances. Assistant Chief Constable Malcolm Graham, John Gillis, Director of HR at Police Scotland, Chief Superintendents David O'Connor, President of the Association of Scottish Police Superintendents, and Callum Steele, General Secretary of the Scottish Police Federation, and Stevie Diamond, Police Staff Scotland Branch Unison. And can I thank you all for your written submissions, and we'll go straight to questions, please, members. Alison.
Before we start, can I draw members' attention to my register of interests and the fact that I'm a council member of Justice Scotland?
And do you want to question? No? No. Well, not yet. Yes, qualify that. That sounds. So I've got John, then I've got Margaret, then I've got Roddy, then I've got Elaine. Right. That's us off to a flying start. Look how alert they are. They must have had their porridge. John.
Of an operational nature, if I may. Panel, the Law Society, Scottish Human Rights Commission have questioned whether there's been a demonstrable or whether the need for change from detention to arrest has been demonstrated. Would you express a view on that, please?
And you know, just to let me know if you want to. Callum Steele, please.
Thank you, Convener. And I'm not entirely convinced that it has been demonstrated. It seems to me that beyond a statement that it is more easily understood by the general public that there is no real reason as to why you would move from the current provisions of detention to moving to arresting on suspicion. It does seem that the notion of creating a new set of statutory provisions which almost identically mirror an old set of statutory provisions, just with a change in terminology, seems to me to be unnecessary.
Does anyone else wish to comment broadly on it? Malcolm Graham, please.
Thank you. We believe that the case is well made in terms of the changes that are required. The previous arrangements, as members will be aware, were designed in the late 70s, a time when the justice system was entirely different in society, was a very different place. The case that's laid out in Lord Carloway's report for why the changes now need to take place and why the recodification should be made is one complete set of circumstances as opposed to changed in a piecemeal fashion is overwhelming, and the move to a consistent terminology around arrest as opposed to arrest and detention, which does cause consistent confusion where the term detention is actually used for somebody remaining in custody prior to court as opposed to a means of temporary arrest, is welcomed.
Yeah, I think, Brian, both concepts of detention and arrest together may in some respects simplify the process, and I tend to agree with both what Malcolm and Callum have actually said. What I would say is that whilst it appears on the surface to be a relatively simple change, I think there will be significant training issues for the police service across Scotland to make sure that everybody fully understands what the change actually means and understand moving from detention to arrest on suspicion as we actually go forward.
I saw heads nodding at training issues. Does somebody want to come in on that? John Gillis, you were nodding your head, and so was and think.
Yes, I think that point regarding training and just the re-education of the service in relation to all of these provisions would be considerable. It's something that we'd have to take a view on it alongside the current change within Police Scotland and reform towards the new organisation. It's difficult to say at this point in time what impact that abstraction would have across the board, and we'd have to give due consideration to how that training would be rolled out. So it's difficult to actually put a cost on it, but I think it's fair to say it would be quite a distraction to the service, and we'd need to decide, well, take a view on when that, if it was going to be implemented, when it should be implemented, based on the ongoing change through the service at this point in time.
Steele.
Thank you. There's also the reality that you can't not know what you know. And police officers, whether they joined in the 1970s or not, know detention. They know the process of detention from beginning to end. And unlearning of that, unlearning of something else, is, in terms of any type of human behaviour, is going to result in inadvertent misapplication of the wrong pieces of legislation and recording of the wrong pieces of information in notebooks, so on and so forth. And I just fear that as a consequence of and I've yet to hear a cogent argument as to why, as a consequence of just changing something's terminology without largely changing its content, why you're going to do something better. But I do fear that the consequence of having perhaps the wrong information recorded as a consequence of dealing with a new set of processes, albeit you might be applying the general principles of fairness, could lead to cases being thrown out of court as a consequence.
Of course, John.
Can I follow up with Mr Graham? Mr Graham, back to some of the evidence we've had from the Scottish Human Rights Commission, and I quote here, unless such evidence, and this is evidence supporting the change, is produced, the greater interference with individuals' private lives involved in longer detention periods may not be justified. And this follows on from their statement, the Commission is unaware of any evidence which suggested that prior to October 2010, the police were systematically hampered in their efforts to investigate crime by the limits of the 6-hour detention period. You say that's incorrect?
I would say that's very incorrect. I think we've brought forward evidence in the past and in our written submission why the 6-hour period was woefully inadequate, and that had become very clear for operational officers, even in, at times, basic cases. Members will also be aware that we brought forward evidence previously and in the written submission about the very proportionate and judicious use of the extensions that have come in since 2010. So we were very clear at the time that we needed a system that could be expanded. We needed a system that was flexible. Whilst in the vast majority of cases, detentions can be dealt with in 6 hours. Certainly the vast majority still dealt with under 12 hours. In the very small proportion of cases that we have sought extensions for 12 to 24 hours, it's absolutely been required. We've laid down some cases where that has been evidenced in the examples and the appendices to the written submissions. And I would strongly argue that without those extensions, the ends of justice may well not have been met, because we would not have been able to gather the evidence in the serious crimes that we've laid out in that appendix.
Can I just ask you to clarify, because in the submission we have got 0.4% of all persons detained required to be extended beyond 12 hours, but we don't have a percentage for the extension beyond 6 hours. Can you give us that?
Yeah, I apologise if the data is not in there. We do have data, and I can ensure that that's submitted subsequently. Of course, it isn't an extension from 6 to 12 hours in the current system, but we do have data that shows the timescales for which people have been kept, and it does show that the vast majority of cases are still dealt with in under the 6-hour period. Of course, the vast majority of cases are less serious cases, and it's this point about scalability that I'd be very keen to try and get across, that the number of cases where we would need to go for an extension beyond 12 is very small, but they are the most critical cases. They are rapes, they are murders, they are complex cases where the criticality of not having that additional time would hamper our ability to keep people safe and may hamper the ends of justice being met.
David O'Connor.
Yes, Convener, just in addition to what's been said, if we can track this back to 1979, when the Thompson Committee first looked at powers of detention and timescales for detention, and the options at that time were 6 hours, 12 hours or 24 hours, and I think the service certainly had a view back then in 1979, of which many people around the table will remember, had a view that the 12-hour detention period would be the most appropriate time. I think the world has moved on considerably, and certainly the 6-hour detention period in some instances is not suitable, particularly for complex and difficult investigations.
Were you disputing that, Callum Steele?
I was disputing that I had recollection of 1979. I was 6 years.
Now you're just showing off. I'm not bothered about that. I think it's important for us to know the figures, because if you're asking for it's up to 12 hours now, if the bill is going to do that, we need to know, well, did it need fixed, which is one of the arguments here, does it need changed from the 6 hours? And if we have that evidence before us, that'd be very helpful. John?
Yep. Slightly changing the subject, Convener, but about custody. And
Before you move on. Does anybody going to do a supplementary on this particular part before you go on to custody? On the arrest?
Yes.
My question's on arrest, isn't it?
Yeah.
Is it on the terminology? On the terminology or not? I would like a question from somebody on that. John?
Well,
you-
Yeah, well, it is connected with the
Okay,
power
I'll
of
let you-
arrest and detention and custody.
Given
if I may.
your previous on this, I'll let you proceed, yes.
Okay, Kavira, thank you. If we've to move from the notion that arrest is a form of punishment administered by the police, then the issue that Lord Carley goes on about is the purpose of arrest, and I wonder if examples that that the committee may be aware of the altered police response to domestic abuse and drink driving and detaining people in custody for that, how present practice squares with the proposals of Lord Carley. Maybe Mr O'Connor might have.
Yeah, in terms of taking that forward, and whilst the bill is being discussed, what we would be looking for is guidelines from the Lord Advocate in terms of interpretation of the bill and how that should be applied by the police in relation to a whole variety of circumstances as we actually go forward, because I think that's one thing we will actually need, is a set of guidelines that the service can actually draw upon.
Would any of the other panel have a comment on that?
I don't disagree with that at all.
And can I ask the purpose of these Lord Advocate's guidelines, as you would see? Because at the moment there are Lord Advocate's guidelines regarding detaining people in custody.
There are, and there's a number of different parts laid out in the guidance set out by the Lord Advocate, and I suppose a key part is that, you know, the officers in charge of the station, as it currently stands, may make a decision to detain that person in custody, and that will not subject that officer to any claim whatsoever. And that's something I think we should discuss as we actually go forward with this.
I'd like to let others in. John, I'll let you back
Yes,
in.
yes, indeed. Thank you.
Thank you.
Thank you.
I've got Margaret, followed by Roderick, then Elaine.
Good morning, panel. I wonder if you could comment on the written submission from ESPS, and perhaps Mr O'Connell first, that the power of arrest in the bill lack an explicit power to arrest to prevent a crime, which is set out in the general duties of a constable defined in the Police and Fire Reform Scotland Act 2012.
I think we were looking for clarification in relation to that. There will be circumstances where, you know, the police come across somebody who is a threat to themselves, you know, and a threat to the public, and in these circumstances, arrest may be necessary to take that person to a police station and to get that person access to the services they may need. And it's just posing a question and seeking clarification that that power will still exist.
That's an important point, because if police are not there to deter and prevent, hopefully, a crime, then that's a huge concern with the drafting of the legislation. Would the others like to comment? Police Scotland, perhaps?
Yeah, I would agree with what David said. We did have concerns about that in an early stage of the drafting of the bill, and we have made representation. We sought some reassurance about the common law powers that David has described being retained, and that isn't included in the bill in a statutory sense. All we have at the moment is I think what's described as a letter of comfort from those drafting the bill, which, to be frank, doesn't give us a huge level of comfort at the moment. So I think it is an issue that we've highlighted. There are other issues round about arrest in terms of ensuring that where at the moment there is a power to arrest, but an offence has not been, a crime has not been committed. So where there's a breach of a civil order and there's a power of arrest attached as well, we need to ensure that that's included for things like matrimonial homes, interdicts, etc., which we would routinely deal with. And we also have a concern round about the absolute requirement to take somebody to a police station when they have been arrested, which we would argue does not retain sufficient flexibility in the system for circumstances where we may wish to, in effect, de-arrest somebody. And indeed, I think Lord Carloway's recommendation was less rigorous than that. His recommendation was that somebody should be taken to a police station.
I did want to go over to that as soon as practically possible, but just to confirm, would it be your preference then that an explicit power to arrest to prevent a crime was contained as a provision in the bill?
I think that'd be very helpful.
Okay, and could I have the view of the other panellists?
I'm glad you're taking over from me there, Margaret. It's quite fine. I want an easy day. I lock myself out of the house. Hey, I'm
You asked me to
free
ask
here.
the questions, Convener. What
No,
can I
no,
do?
go for it, Margaret. Go for it. There we are. Who wants to? Please indicate, as usual, if you want to come in. Don't feel obliged if you have nothing to add. Callum Steele, I'm sure you have something to add.
The only thing I have to add, Convener, is that I have nothing to add.
Do you agree or not?
I agree.
And Unison, do you have a view?
We don't have a view on that.
You don't. Okay. Well, I like to give everyone a shot.
I
Convener.
know, but I'm feeling peeved.
all right, if you're
don't make me
peeved, then.
peeved. I'm very vulnerable.
Do you want me to leave as soon as practically possible?
Certainly not. No, no. I don't want to exercise an arrest on a person who's simply not officially accused. There's one thing that hasn't been addressed here, and I was hoping John might have done it, and that was this word, detention and arrest. You know, when you say arrest under suspicion to the public, they think you've done it. I mean, you're telling me that it's, the understanding of the public will be clearer. To me, it's not. It's unclear that if you're detained and it reports in the paper that man's been detained for that, that woman's been detained for it, that's one thing. But you say, see, they've been arrested. They're not going to notice the, what's the words, not officially accused. So can you comment on the language, which I thought that John was going on?
Convener, I think that gets to the very nub of what this whole thing is about, because the notion that it is more easily understood, I have yet to see evidenced anywhere. And I just look south of the border at some of the recent examples that have taken place there, and I know that there is some civil litigation ongoing, so I'll be mindful as to how I phrase my response here. But in the murder murder inquiry of Joe Yates, the landlord of that the building in which he was murdered, who happened to be quite an eccentric-looking gentleman, Christopher Jeffries, was arrested, and it was reported that he was arrested. Now, I can't speak for what the general public across the whole of the United Kingdom thought, but my sense from the subsequent furore around it is that they thought that this man was guilty because the terminology that was applied to it, that he was, in fact, arrested. Now, I don't sense, and I have not sensed, that when individuals are detained in Scotland and then it is reported that they are subsequently arrested, that there is a difficulty in understanding the difference between the two. But like I say, that's just an observation.
Yes, Malcolm Graham. Yes, I'll let you know on that.
I mean, I've got a contrary view, and I don't think that the cases from England and Wales bear comparison because we're in a different system. The case that's referred to in England and Wales, there's a power to detain for up to 72 hours. And I think in that actual case, that extension was granted, albeit except through going for a judicial submission in relation to that extension. We have a far more limited form of arrest, and an arrest on suspicion, as is proposed, would still be for a maximum of 24 hours. Convener, with due respect, in relation to...
With respect, it's the perception. This is true technically, but we're back to, and I think that's not sub judice anymore, the case you mentioned. So I think the concern is, innocent people perhaps being found guilty by press, by tabloid press, and even by broadsheets. I think that's the concern. And I think that's perhaps shared by the committee. So technically, yes, but yes, I'm letting Rod, you want to come in on that as well, and comments from other members of the committee, and then Sandra.
This question of what arrest means. Arrest under the bill is not defined. Lord Carloway in his report recommended that arrest should be defined as meaning the restraining of the person and, when necessary, taking him or her to a police station. Just be interested in the panel's thoughts on whether or not there should be a definition of arrest, and indeed on what Lord Carloway actually recommended.
If I could maybe start that, Convener, I kind of grew up, my understanding of arrest is a person is no longer free to go about their lawful business or have not been advised that they're free to do so, and that's the kind of definition that we've worked with. It's a definition that's common throughout the service, and, that arrest puts controls on an arrested person. It allows the police to do a number of things, in terms of controlling that person. In terms of Lord Carloway's definition, and I don't have it in front of me, the first part of it I can understand. The second part of it I'm not sure of, and it probably takes us back to the issue that Malcolm was raising about de-arrest, you know, and the ability to de-arrest in certain circumstances, because there will be occasions where it is necessary to arrest somebody at a locus or some other place, some other area in a public place to confirm their identification and the like. And once that's been done, you know, potentially the grounds for arrest no longer exist.
Yeah, if I can go back to the previous points, I think it does flow into that question. The very fact that we're having a discussion about the terminology in terms of what the definition of arrest might be, and I think what David's just laid out, and indeed the definition that Lord Carloway lays out, is very similar to the definition of what detention would be at the moment. Somebody's not free to go about their business and not at liberty. I would strongly argue that the public notion of that is not influenced by any communication or public information that's put out by the police, because we don't release information about individuals until they are arrested. And I think that there is less likely to be a distinction in people's thinking between what happens in Scotland and what happens in England and Wales. I think people are probably largely influenced, as Callum Steele's pointed out, by media that they pick up from across UK sources, and therefore the differentiation in their minds is less likely to be as great. In relation to the point round about the definition of arrest, I think it would be helpful if arrest was defined in the Act, as Lord Carloway has outlined. And as I mentioned earlier, we have got great concerns about the absolute requirement in the bill as it's drafted to take people to a police station at any point that they are arrested. And indeed would agree with Lord Carloway that terminology like when necessary would be far more helpful in ensuring that people are not detained longer than is necessary, and ensuring that people's liberty is not taken from them unnecessarily, because the process of going to a police station and going through the process of somebody's rights quite properly needs to be done thoroughly and can take some time. And we've laid out, I believe, in one of the appendices to the written submission, a number of scenarios where we believe it would be in the interests of both justice and in the interests of the suspect that we were able to de-arrest them at a stage before they were taken to a police station.
Funny feeling de-arrest hasn't got a sexy ring to it. See that man that was arrested, not officially accused, is now being de-arrested. I don't see that as banner headline somewhere.
I'm afraid inevitably new legislation sometimes brings up new words, and if I've just made that one up, I do apologise.
Oh, I see. Oh, well, that's it. You're in the public domain. I've got supplementaries to this. Sandra and John is supplementary. Roddy, sorry, I beg your pardon.
To hear what Callum Steele in particular.
Were you wanting to say something here?
On that point?
Just that I pretty much ally myself almost entirely with David O'Connor's comments that the definition of arrest that the police service uses just now is well understood, it's well applied, and I don't think it causes any confusion, unlike what I think we're about to create.
Okay, thank you.
We've heard your views, and I think we know them. And so sorry about this. A lot of people want to pop in here. Sandra, then John on the same point, is it? And then I've got Elaine, and I'll take you out, Sandra, from my list. Sandra now. No, but you're on my other list.
Criminal Justice Bill has been taken out. That sounds really, really good at this time in the morning. Thank you, Convener. The issue you raised in regarding the perception, I think it's a really important one. It's something that we should maybe discuss more. It is, you know, the perception out there is if you are detained, you're detained. If you're arrested, you're guilty of, or you're suspicious of some crime. And I don't think there's any getting away from it, whether it's the tabloids here or the tabloids down south or wherever it may be. But I wanted to look maybe a wee bit beyond that. If someone is detained and their employment and they have to tell their employer they have been detained, that may be understood. But if someone is arrested and they're not charged with a crime and they have to tell their employer, well, actually, under this legislation, I have been arrested, how will that work for the person involved? I mean, I have quite, you know, lots of concerns regarding the definition of detention and arrest. And I completely understand what you're saying about the 6 hours. Perhaps it's not enough time to get a lawyer there, etc. That's maybe going away from it altogether. But I do think we really need to either have the definition on the face of the bill so that people completely understand what it is. I mean, I know that the police obviously understand it. The public out there think if you've been arrested, you've been arrested. And how will that work with someone who's in employment?
I take the point, and perhaps what we need round about whatever is passed into an act is a fairly sophisticated piece of communication that's going to try and inform people as to the changes that have been made. I'm not aware, and I've worked fairly extensively with some of the legislation down south in England and Wales, that perception is vastly different. I'm not aware of any evidence where people in England and Wales would have a wider perception that perhaps because they have been arrested on suspicion, they are therefore guilty of a crime. I think people largely understand one of the key tenets of the justice system across the UK, and particularly in Scotland, that you're innocent until proven guilty, and that whether you are detained or whether you are arrested, that your guilt or innocence is decided at the point before which you go to court for that decision to be made, and not whether the police have either detained or arrested you. So I don't see, or I haven't heard any evidence that that perception would be different in England and Wales, where they don't have the concept of detention. And indeed, I now find it confusing to be talking about the terminology where, through the course of his report, Lord Carloway uses the term detention, meaning when somebody is to be kept in police custody after arrest. And I think that is fundamentally confusing now.
Just on that, I think the key part in terms of detention is arrest. We currently have detention on suspicion, and we're moving to arrest on suspicion. The key words in there are on suspicion. So, I mean, I think that's the part that we need to focus upon.
I'm afraid I think that perhaps the public keyword will be arrest. I think that's the issue. I mean, as politicians, perception is, we know that perception is a huge part of anything. And while I can see the technical arguments, I think, I don't know, we'll see other committee members, I remain unconvinced at the moment that changing that terminology is helpful. And I think the issues raised by Sandra White about the perception, whether or not employers do anything about it, perception amongst other employees if you're then arrested on suspicion, it's very hard to shake that mud off you if it's been thrown. You know, in these cases. And I think your case is undermined by the Yates case, where you say, I don't think people in England have had that view. Well, they did. That man was convicted, hung, drawn and quartered because he looked odd, and the press ran the story, and he was arrested. So I think your argument with that very case is undermined by it. And that's my take on it. And I don't know, I'll ask other committees. John, your view?
I'd like to read an extract from Lord Carloway's report, and it says the review considers that the opportunity should be taken to simplify, modernise and clarify the circumstances in which, where an individual is under suspicion of having committed a crime, the lawful deprivation of his or her liberty can take place. And I think perception is important, and I think that this committee has an obligation to provide good law for the police service to follow. I wonder in relation, and it's to press on this, Mr Graham, on the difference between arrest and detention, and I share my colleague's view that I think the public will take the view that arrest is something more definitive. And I wonder if one of the unintended consequences of that may be an unwillingness thereafter, because you say that would be the trigger point for publicity, someone has been arrested, someone not coming forward with information. You know, they've got all the need to arrest the person's in custody. I'll not bother going on with this snippet of information because, of course, the police service relies on the public engagement in that level.
Can I clarify, do you mean what, at the point between which somebody currently would be detained and prior to them being arrested?
Well, I'm meaning under the proposal, someone would be arrested. You say that would be the trigger for information to be released. So Joe Bloggs is now in custody, and a member of the public will say, well, they've obviously got the wherewithal to have that person there. I don't need to come forward with this bit of information which may or may not be helpful.
Well,
and of course, indeed, could be crucial.
I think if I can clarify, when I was using that as an example, I meant that when somebody's arrested under the current scheme, that would be the trigger when we would be likely to release any public information. And that wouldn't include the details of an individual until they appeared at court. Under the proposed Act, it would appear sensible that that would remain, and therefore there wouldn't be any release of information until somebody was arrested as a person where they could be charged under the current system, and therefore I don't see that that would change because we had moved to a position of arrest under suspicion. So I don't think that would come into the public domain in the way that you've described it, and I don't think it would change the public perception. I do take the point that the term arrest has a different feel in the public sense to detention, and therefore I think we should focus on arrest under suspicion. But it's not my understanding at the moment that there is a huge amount of information out there when people are detained in that short period, either prior to being released or in many cases where they are arrested in the current system. Perhaps it would be helpful, I don't have the figures to hand, if we were to come forward with some information, assuming that it were available, about the number of people that are detained and then subsequently released where the grounds no longer exist, as opposed to the number of people who are arrested and charged. And that might give you a
Data's always
sense
helpful.
of that.
Data's always helpful. Callum Steele, followed by David O'Connor. Callum?
I don't doubt that as a general provision, the position narrated by Mr Graham is in fact correct, and that, you know, press releases, when they are generated or put out, will come on the back of arresting and reporting to the Procurator Fiscal. But that's not true in all cases. There are examples, and I hesitate to give any just now, but I can say with some degree of certainty that there are examples, usually in the higher profile cases, where there is an awareness and there is a significant media interest, where the police will notify by way of release or notification to the press that individuals are detained and helping police with their inquiry. So as a general provision, the notion that it is only done when the arrest and the charging takes place is in fact not 100% accurate, because there are other examples, usually the higher profile cases, where in a bid to provide some information to those that are interested, notification of detention is made known.
Convener, it's really just to pose a question, and it's perhaps something that the Justice Committee may want to consider. We've talked about arrest and detention and the potential impact upon arrested persons, but perhaps a question should be asked of how victims or complainers would feel about that particular matter or this particular statement. And they may well have, those groups and organisations representing victims may have a particular view in that, but that's something we can't lose sight of as we actually go forward. What is their perception in this particular matter?
I think the question should be what is just. And the perception here may be unjust to someone who's been taken in under detention. Because if we link that, I'm going to go on now to Elaine. I think I've run. Are you on a different thing?
I'm on a different topic.
Okay, okay.
I wanted to ask about investigative liberation, with the suggestion that you should be released on conditions which may be applied for a period of up to 28 days. Both Faculty of Advocates and the Law Society believe that the period should be able to be reviewed by the courts. I know that Police Scotland and the ASPS suggest that 28 days is too short a period of time as a maximum, and also that Scottish Women's Aid believe that the complainer should be required to be notified of the suspect's release and presumably of the conditions of that release. So if you could maybe give your views on who should be reviewing the period, whether 28 days is sufficient, and whether the complainer should be notified of the release and the conditions on which the suspect has been released.
Thank you very much, Mr Graham.
Okay, thank you. I mean, investigative liberation is one of the areas I believe that Lord Carloway took from a number of visits down to England and Wales to look at the PACE Act, which has been in place for some 30 years and worked in a slightly different way that is proposed, but worked well as we understand it. We do welcome the step to introduce investigative liberation, but as has already been said, we do feel that 28 days potentially as an absolute would be restrictive. And on occasion it may not be sufficient and proportionate in circumstances where we could justify an extension. We don't make any proposal for what that extension process should be, whether there would be some sort of repair to the court, a judicial process, and reviews within the 28-day period. I think we have suggested that we would be happy to look at that as an internal process. We would, as with all other custody processes, etc., we normally have guidelines for review that are not necessarily laid out in statute. And again, I don't think we made any distinct proposals that that should be the case.
Wish to comment, Callum Steele.
I mean, my understanding is that the time period relates to the time in which the conditions are applied to the investigation. It doesn't necessarily mean that the investigation in its own right ceases after 28 days, and indeed it would be entirely right and proper for investigations to continue, irrespective of whether conditions applied to interim liberation apply or otherwise. But I would like to move on to some of the additional issues that are associated with interim liberation, as well as addressing the question as to whether victims and witnesses should be made aware. The SPF gave a fairly comprehensive response to the Victim and Witnesses Bill on that, and I'm fairly content, without reference to it in front of me, that our view was that as much information should be given to victim and witnesses at key stages of the investigation and inquiry as is possible. So I would absolutely have little hesitation in supporting the view that they should be made aware when certain conditions apply or cease to apply. But when it comes to the notion of the 28 days in interim liberation, or even interim liberation in its own right, I think that that is probably a sensible thing to do. But then you have to look at the mechanics as to how these kind of things happen. We have to look at the availability of solicitors. We have to look at the availability of police officers. We also have to look at the availability of suspects. And I'm just mindful of how day-to-day policing takes place. And the fact is that traffic can stop someone being at a place at a particular time when they were meant to be. And there is, I fear that there is quite a significant potential for police officers, solicitors, and suspects of offences missing each other as a consequence of time, where perhaps an interim liberation is said to be at a particular time and place at midday. The police officer themselves might be there at midday. Solicitor might be there at 10 to midday. Suspect doesn't turn up till 1:15, by which time the police officer said they're not showing up and they go off to deal with something else, and then they turn up, and then we're talking about whether we're going to arrest someone for breaching their bail conditions or not. And we have a potential to complicate the criminal justice landscape with what in their own right could be sets of circumstances explained away by timing. And also the fact that, we because of the dynamic nature of what police work is, the suspect could well be there at the appointed time, date and place, but as a consequence of the police officer being held up dealing with an incident that they may well have attended in good faith in the reasonable expectation of being clear in a proper time frame, is unable to get back to the police station. And then when you deal into that, the fact that someone has got to be standing there with a stopwatch, metaphorically, switching it on and off to make sure that the overall time is not exceeded, that in its own right is going to be an awful lot of administration or an awful lot of IT, but one thing it's going to be is an awful lot of expense. And at a time when the police budgets, and indeed budgets across the whole of the public sector, are under massive pressures, I'm not necessarily convinced that proper consideration has been taken of the expense that is going to be associated with the administration of that particular process. However right and proper I think it is, and I do think it is right and proper, that the ability to continue investigation after the formal period of arrest or detention, or whatever it's going to be called, comes to an end.
To comment. Yes, David.
Just a little bit confused there in terms of we're talking investigative liberation or interim liberation. I mean, investigative liberation is when somebody is suspected of a crime, and that 28 days applies. Obviously, various conditions can be applied, but the interim liberation is where I understand somebody has been charged, and the interim liberation is conditions that can be imposed upon the accused until they appear in court. And I think the interim liberation is an area that perhaps would be worthy of further discussion.
Now, at this moment,
Yeah,
yes,
well,
please.
If it's okay. I mean, currently
Hanging in the air.
yeah, currently police officers have the power to grant unconditional undertaking with standard conditions when releasing accused persons from custody. That can include not to commit a crime, not to interfere with witnesses, not to behave in a manner which causes likely to cause alarm, and comply with any other special conditions. Under the proposed legislation in the bill, the thresholds associated with the application of the conditions to a written undertaking have been revised, and they continue to allow police officers to have unconditional undertakings to appear in court. But beyond that, an inspector or an officer of the rank of inspector can apply an additional condition where it's necessary and proportionate only for the purpose of ensuring that the accused does not obstruct the course of justice in relation to the offence for which has been investigated. So that's moving on from what we currently have in terms of basically the police powers that we have to prevent further crimes being committed. We can apply these standard conditions and additional conditions, but as we move forward, what's proposed in the bill is an inspector applying a condition only in relation to the charge which is under investigation.
The investigative
Yeah.
liberation as
Yeah.
opposed to
This
liberation.
This is interim liberation I'm talking about.
Interim liberation.
Interim liberation.
Okay.
Because it
But
can be very
investigative can spread its tentacles further.
But it can, but it's very confusing.
Okay.
The two
Yes,
terms.
I've just been confused.
Yes.
Malcolm Graham.
I'm going to try my best, as indeed this whole legislation is trying to do, to simplify things. With your permission, I'm grateful for David moving it on
Mark
to...
your points out of 10 then.
Well, release on undertaking, I think, is the term that's used for the interim liberation, or certainly the term that we would use. Investigative liberation, with your leave, convener, if I could go back to that point that was made, I agree with Callum Steele that whilst we welcome it, and the intent behind it is about minimising the time that people should be kept in custody, whether detained, arrested on suspicion or arrested subsequently. And we support that intent, but I do agree with the complexity of it, the systems that will need to be put in place, and we have outlined that, and indeed the detail of some of the costs in terms of the systems, because it would be requiring an ICT system and upgrade, as many of the sections of this Act will require. And there is a complexity in managing that, a complexity for people, a complexity of systems that will undoubtedly come with a cost, but we welcome the intent. Moving on to then the undertakings.
Can I ask you a question here? When you're doing your investigative liberation, if in doing that in relation to a specific offence you turn something else up, what happens if you think there's a different crime also being committed? What happens? Because there have been for investigative liberation for a specific crime that you're thinking about, but in the middle of doing that you find something else. What happens then?
Well, I mean, that's not an unlikely scenario, as would happen at the moment when we are dealing with people for one crime. We may encounter another.
So what happens in this?
You would investigate that crime either if the circumstances were connected with the crime that you're investigating, then you would have to take it as a whole. In other
say
words,
it wasn't. Say it was something
completely different. Then you would deal with it separately, and it may be that you would deal with it at that time within the same constraints. So you wouldn't be able to add another 28 days on, as it were, and say, well, we'll take 56 because we found another crime, which clearly wouldn't be in the interests of justice or fairness, if that's the point, convener, that was being inferred. But I think at the moment, if we have 6 hours and we uncover another crime, then we would either deal with it later, i.e. you would need to come back and detain somebody at a separate time, or you would need to deal with it within the constraints of what you were dealing with. In the same way that if we are out searching a house under, for instance, a warrant that's been issued on suspicion of drugs, and we find a gun, then we might go and get a warrant to search further for firearms because we now have that suspicion, but we would carry on and do that.
You kind of a fishing warrant. I mean, you could.
Absolutely, and it would be the same in those circumstances, I would imagine. I don't think there's any detail of how that would be dealt with in the investigative liberation as a concurrent process.
That. Deputy Convener here doesn't understand this either, so if you can maybe not make me feel so foolish.
If under investigative liberation, you come to the end of the 28 days, right? What happens then? Is it the conditions are lifted, but you can continue going on and investigating?
No,
or you have to drop the case, or what happens?
My understanding is that the conditions would fall, but the investigation could continue, and that is our concern at the 28 days, is that it's a period which has no doubt been chosen based on a judgment round about proportionality, but our concern would be that that period, whilst being absolutely fine for a large number of cases, for a number of longer running, more complex cases would not be. And I think we've laid out the details of some of those cases in an appendix to our written submission. And therefore, we would contend that to put in place a system where you can extend the 28 days, it would mean that the conditions that come with that could be extended as well. Otherwise, it does just become a cliff edge that you fall off. The investigation continues, but then
Would still be at liberty, but the conditions, for example, if it was a curfew or you were told not to go
Yep.
anywhere near the complainer or whatever, those would fall after the 28 days.
the conditions would fall in a rather arbitrary sense, arguably.
John, you want in here, you've got a face that looks
Well,
as if you disagree or something.
I'm never sure when enough's enough. Would 6 months be enough, Mr Graham, or a year, or how long would you see that
I don't think
cliff being on the horizon?
I don't think we've sought to put in a period of time that it could be extended for, and clearly there would have to be a limit to that. But you know, it would be reasonable that there would be a period beyond the 28 for the exceptional circumstances that we've highlighted in the case, but perhaps another 28 days.
And you would see that as being judicial involvement in that, granting that extension, rather than chief police officer?
I think you could do it either way, and again, as is the case with various sections in this bill and various other pieces of legislation, there are different measures in place, whether it's coming back to a court or whether it's a specific rank that's specified within the police and legislation, or whether that's a matter of guidance either from the Lord Advocate or for the police to make a decision about. And we haven't made a specific recommendation, but I think we could work with either.
Can I go back to your investigative liberation? And so you've had somebody in and they've been arrested, I've forgotten the term already, you see, whatever it is, not officially charged or under suspicion or whatever. So and you've set them out with conditions for 28 days, but that's relating to what you thought they had done. And in the middle of doing all that, you find something completely different that they may have done. But your 28 days and your conditions apply to that first thing. So what happens to the second? You have to get them back in and say you're now arrested on suspicion of having done something. And we've got another 28 days running because of this separate thing, nothing to do with the first job.
Well, there might be circumstances where it would be reasonable
So
to
I was
do that.
trying to work out. I mean, it's not connected at all. So you could have 2 or 3 things, all with this technical stuff running.
And that would be the same under the current system where somebody's detained,
Okay.
albeit it's far shorter timescales, that would be the same. Now, the fairness to the accused person when you get to court test would have to be met clearly.
Yes.
And therefore, if the circumstances were part of the same course of conduct, the police would not be seeking to try and commence a separate process.
I appreciate that. I'm being very clear. It's completely separate. Something never occurred to you. Oh, whoops, this has turned up.
Yes.
Just want to understand how these things would operate in terms of it. Margaret, you wanted in here and then Sandra.
Yeah, it was just and I think you've covered this to an extent. The Faculty of Advocate and Law Society believe that the period of investigative deliberation should be reviewed by the courts. Is that something you'd like implicit in the
I think we would be satisfied that that period could be reviewed depending on the timescale and the extension by a senior police officer, but we could work with either system.
Anyone else have a view on that?
It never surprises me when the legal profession wants to have more work.
How cynical.
I hope you're never up on anything yourself. There you go.
Still on the liberation, if you...
Yes, please, yes.
I don't think this... I know Elaine Murray mentioned Victims Scottish Women Aid, but they specifically wanted the requirement for the complainer to be notified if on the suspect's release on investigative liberation, and also if there are any conditions attached to that liberation. Do you have views on that request?
I'd be very happy if that was the case.
It's a bit like bail, isn't it? So the bail conditions.
And that wouldn't be over onerous to do it. It would be quite reasonable. Mr. O'Connor?
Presumably they'll
Yeah, I mean...
Free-for-all. Hang on a minute. Yes, right.
No, I just have to say, and it's going back to a point that Callum made, is that, you know, the impact on police resources shouldn't be understated in terms of this type of liberation. And in addition to that, you know, what we'll clearly need is some form of technology to support this, because, you know, in terms of custody management across Scotland, you know, and tracking all these different types of investigative liberations. I mean, there would have to be some kind of technology, and that's something that Police Scotland need to work towards as we go forward.
So you would expect that to be built into the IT system that they're currently looking at?
Absolutely.
Okay, thank you for that.
Sandra. John, I'll let you in because you've not been in yet. I'll let John in.
It's all right, convener. My questions
Okay.
similar to Margaret's and they've been answered.
John, do you want to come in?
Just supplementary to what Margaret had asked there about police resources, but obviously, Callum, in your general comment, you think that sometimes the resource and the cost is not going to be worth the benefits that we're going to draw out of this. Do you then believe that what David is asking there, that this might just be a waste of money if you don't think there's going to be any significant benefit?
I think that's a very loose paraphrasing of what I said. What I'm saying is that at this particular moment in time, the police service, like every other public service, has got little money. And the notion that we're suddenly going to materialise or magic up the amount of money that's going to be required for bringing about the necessary IT systems, for bringing around the changes in training that are going to be required, and for putting in place the staffing, be that police officer or police staff, to deal with the management of the clocks or the times, to make sure that there is no overall breach of the timescales that are applied in an investigation, may not necessarily be there. And the notion of doing it piecemeal is in itself a complete waste of time, because whenever you do anything piecemeal, it never works, and invariably by the time the rest of the service catches up to what would have been a very low common denominator many years on from the start point, much of what you're dealing with is antiquated and further out of date than it was to begin with. The issue of investigative liberation, just to be perfectly clear, I think is a good thing. The practice in its own right is a good thing. But what I am saying is that the resources required to make it happen, and to make it happen smoothly, not just in terms of the effectiveness of the police service, but in terms of minimum of disruption for the legal profession and indeed the suspects, are, in my view, significant. And there's no indication as to where that resource is going to come from.
Alan, why should we be able to give obviously the example with regards to investigative liberation? Is there any other examples where you believe that there might be a danger if the resource doesn't follow? I mean, what practical challenges would you see following the implementation of this bill?
Well, simple things in terms of going back to where we started with arrest and detention. I'm sure that Stevie will talk about it shortly, because I know he's got very intimate knowledge on it. But some of the computer systems that are used at this moment in time across the Police Service of Scotland still require the use of a floppy disk. Not just a 3¼ inch floppy disk, but a 5½ inch floppy disk, a genuine floppy disk. Now, the notion that we are able to simply replace that in its own right, just because of having to change the terminology and the approach to arresting someone on suspicion rather than detaining them, is, in my mind, fanciful. Where those computer systems aren't used, and that's largely in the more rural areas, and we have paperwork and correspondence to go through, that in itself is methodical and logical in terms of how it's put forward. The notion, again, that we're going to destroy stocks of paperwork simply because we're giving something a different terminology is, to my mind, a nonsense in its own right. And the fact that we're going to be training people, or expecting to be training people, in what is essentially the same provisions but in new clothes, again, doesn't seem to make any sense. So at a time when the service has got least resources in terms of actual cash, to be adding a burden which seems to deliver the least benefit, to me seems particularly burdensome and difficult to justify at a time when whatever resources are available could be utilised for dealing with the very real challenges that the service has on an ongoing basis.
Having said that, I see Malcolm Graham and Steve Diamond. I'll take Steve Diamond first this year. And we're coming on to your bit eventually, which is the negotiating board, isn't it? Bear this in mind, we have another part to ask about. You want to come in this as well? Have you spoken yet, Mr. Diamond?
Once, yes.
Well, I'll allow you
for
once.
a very short time to say no.
Then I'll take David O'Connor. So I'll give them the opportunity first.
Back up what Callum was saying there to Mr. Pentland. Just a couple of examples of the administration that's happening at the moment. For example, the new rights for solicitors to access suspects. has created a bureaucracy behind that, so that the police can accurately record it. Because our IT systems are so outdated, it's a paper process no matter where you are in the country. So that's particularly burdensome. But also the I6 programme, which is coming into play probably around about 2015, which is what we would expect to administer this whole process, is currently in the definition stage. So until this bill comes into play, I6 has still got to go on because it's got to be delivered by 2015. So we could be looking at a rejigging of I6 before it even starts to accommodate this.
That's on how the subcommittee could return to, I think, because we've already looked at that. Could we, Mr Gillis, you want to come in and then...
I think my observation on what Callum was saying, I think it just need to kind of be clear that we separate the issue of cost and timing of doing something as opposed to whether something's right to do. As you've heard from my colleague Malcolm Graham, have said that Police Scotland is broadly supportive of a lot of the recommendations in the bill. Yes, we're challenged just now in terms of resource, but we're going through a huge process of evolution. And if this is something that's going to enhance the service to the public and to victims, then I think we should separate that from the timing of when we do it and the cost to doing it. Because if it's a priority, then we need to look at that strategically rather than push it back because it's in the difficult to do box.
Pass the legislation and see if we can afford to do it.
Pass the legislation and then establish how we're going to do it to best effect for the people of Scotland, based on other priorities within the service.
Mr O'Connor.
Yeah, just to go back to Mr Pentland's point, and you know what, I mean, there is various parts of this particular bill where there'll have to be very robust checks and balances built in to ensure that all the different parts, different conditions are actually being applied and are actually being delivered. I think this will have a significant impact upon inspecting ranks, and a lot of Callum's members, they have a particular locus and role to perform in reviewing written undertakings, investigative liberation, extension of detention. It shouldn't be understated at a time when the service is going through a significant amount of management delayering, and when we talk about resources, I think we must make it quite clear that the issues in terms of checks and balances and review are not insignificant for inspecting ranks in particular.
Thank you, Convener. I agree with much of what has been said. The point round about the dependency between the service's ability to deliver an ICT system that's fit for the service in the shape that we're currently in, and the implementation of this Act is absolutely key, and that's a dependency that we've recognised from the outset. That work is ongoing to ensure that the I6 programme can be designed at the stages it's at to encompass as many of the proposals that are in the bill. But there is the point that Stevie made is absolutely accurate, that we can't design those in with any degree of certainty until it is an Act. So the phasing of that is critical, and the dependency is clear, and we don't want to have to put in place paper systems which are cumbersome and bureaucratic to service the needs of some of the complexities of this Act, if we can get the opportunity to design it into an ICT system that is going to be delivered after the time that I understand this Act may be enacted.
Also got all your duties under the Victims and Witnesses Bill, which is coming up, which again will need to be tracking everything and data and so on. Is too much being asked?
I don't think anyone that would be watching this just now would think you're ever asking too much of the police service in terms of what the service we're meant to give the general public. But sometimes the burden, whether it's self-applied or applied by others, in terms of how the day-to-day policing activity takes place, can seem too much. And in much of what's likely to come out of this bill, that burden is not insignificant at all.
This is, without overstating it, the most significant piece of legislation since the 1980 Act that we have referred to, and the largest change being proposed in terms of criminal justice and how that impacts on policing since that time. And I would say that the change is required. We're supportive of what is in it, but there will need to be a recognition that there will be a cost associated with that. And we have worked very hard to accurately assess and capture those costs, and that is represented in the financial memorandum that accompanies the bill. So I do agree with everything that's been said, that a lot has been asked, but this is a generational change that this is not going to be a recurring event every 2, 4, 6 years. This is a generational change that we need to commit to for the right reasons, as John has said. This is about some fundamental changes in terms of human rights, in terms of as a society and as a legal system, being able to ensure that there is that fair and equitable balance between the rights of those who are accused or suspected of crimes and victims, and I think we should commit to doing that properly.
Yeah, I think, Convener, it's a matter of timing, and we're 6 months into Police Scotland. We've seen one of the biggest changes to policing in Scotland, or the biggest change we've ever seen. In the back of that, we've got one of the biggest changes in a generation to the criminal law in Scotland, and it's a matter about timing. And it's for me, and I know there is a longer running in terms of the legislation, but back to where I started, there has to be that understanding, there has to be that knowledge, and there has to be that training for police officers and police staff as we actually go forward. It is a big ask, but it's doable.
John, you want to...
One final question on this, Convener. I become a wee bit concerned when we know that the police board, the police authority, have to save something like £72 million in savings next year, and we have heard that if this bill has been implemented and has to be implemented successfully, could I ask the panel directly, do you think the only way that that's going to be successful is if the money comes along to make that happen?
I can answer that very clearly, that the reason we articulated the costs in the way that we did was because there are additional costs associated with this bill, and as you rightly point out, it will be very hard and increasingly difficult for us to find those costs from within the existing budget that's been offered to Police Scotland.
Anybody else wants to comment on costs? Or on resources, generally staffing and so on, yeah.
I do think that the question asked is slightly oversimplified. The success of the bill will very much depend on whether the right things are contained within it, but the ability of the police service to deliver on its expectations, I think, are absolutely going to be dependent on making sure that the correct amount of money is given to the service to make it happen.
Yes, Mr Diamond.
We're all around the other huge financial constraints over the next 2 years, so whilst we agree that that this bill is required and is needs to go forward, there's got to be a realistic expectation about when it's going to be delivered and how it's going to be delivered, and if that funding is going to come from within the service.
So are you disputing the financial memorandum?
Not as such, but what we're saying is that it's got to be a realistic amount of time to actually deliver what's required of the bill.
Somebody else wish to comment on resources fund? This is your chance to tell us.
Yeah, everything comes at a cost, and I suppose we need to look at the value of this piece of legislation in terms of keeping people safe, improving services to victims, improving the criminal justice system. It is conflicting priorities and competing demands for dare I say it, a never-reducing pot of money. These are very, very difficult decisions that have to be made by the Chief Constable, but for me and for us, this is certainly a piece of legislation that has been costed out and must be taken forward.
We're running into a long day, and I've still got questions on the Police Negotiating Board, but I've got Alison and then Roderick.
If I might, Convener, just take a moment to look at section 27 and post-charge questioning. Police Scotland have welcomed this suggestion. Others, such as the Edinburgh Bar Association, have urged some caution, and Justice Scotland considers, and I quote, the perceived value of post-charge questioning is overstated and is unsure of Justice is unsure of what value it will add in the Scottish context. I wonder if Police Scotland were able to give us their views on why they've welcomed this or not.
Yeah, I think we have given it a cautious welcome. As you point out, it's not something that we have experience of. It is something that we have experience of wanting to do on a number of occasions, particularly in serious, complex cases that are long-running, where potentially the point of charge comes at a stage in the investigation where there is still a large amount of investigative work to do, in fairness to the person that is accused and the wider interests of justice. and therefore to be able to go back with questions would not only further the investigation but be deemed as being a fair opportunity should an individual who's accused wish to provide more information than we had the opportunity at the first point of questioning. So we welcome it for those reasons. Our best guess, and it's a professional judgment, is that it would be used sparingly. This is not something that would be getting used routinely in more straightforward summary cases, and it would all likelihood then be in consultation with the Crown where we were going to use this tactic should it become enacted.
And do you think there's any conflict with ECHR in relation to this?
I don't see any conflict in the way that it's laid out in the courts and the argument for it being a proportionate balance within the justice system, obviously on a case-by-case basis. As is the case with everything that the police do, that would be a test that would be considered by the court.
Do you think there's any benefit in trying to limit and set out more clearly just what circumstances that this questioning could be done? For example, perhaps when it deals with evidence which has come to light after the charge was first brought?
That's clearly one set of circumstances at the moment where we sometimes wish that we had a device or mechanism for doing this. I think it probably extends beyond that, as I said in the first instance, round about more serious and complex cases where at times due to the volume of material that information might be there but we might not have got to it at the stage that we're requiring to put other processes in place. So I don't know we would want to be constrained to that specific limitation, but it would undoubtedly be one of the sets of circumstances where it would be relevant.
Thank you. Roderick.
Move back to section 25, gentlemen, consent to interview without a solicitor. I just wondered whether the panel had views on the suggestion in section 25 that 16 and 17-year-olds who are not suffering from a mental disorder can consent to be interviewed without a solicitor with the agreement of a relevant person. Views on whether they should be allowed to waive the right to a solicitor?
Very topical discussion just now about the ability of 16 and 17-year-olds, and given that today we're about to debate whether they should be allowed to vote, in fact not whether they should be allowed to vote, and that they know their own mind in that particular regard, then you can understand why the argument could be advanced both directions. But then of course there is the additional balance in terms of the criminal justice system, the definition of when someone becomes an adult. And I don't have an answer for that. I will leave that to the legislators.
Thank you.
I would share those concerns as expressed by the Police Federation. I think an additional concern in some of the implications that flow from this whole area is where there might be a set of circumstances that the police would in effect be instructing a solicitor on the behalf of a person who had already stated, whether with questionable competence or otherwise, their desire to waive that, and how that would work in terms of who was actually instructing the solicitor. And I think we say that from the perspective of seeking to achieve the same aims as the whole bill, and indeed Lord Carloway's aspirations. But I think there is some technicality around about that instruction coming from the police as opposed to from the individual who rightly should be instructing the services of the solicitor.
Is there some kind of confusion? I mean, we've just done the victims and witnesses well, and I'm trying to recall, I think the age at which treated differently is 18. Mm-hmm. So why are we still sticking with 16 years? It seems to me that, you know, a witness can also be a victim. An accused can also be a victim. I mean, why are we not tidying this up? Would you like it to be? But we rephrase it, Mr. Steele. You've been awkward with me. Would you wish that this was a person is 18 years of age or over? Do you want it to be 18 so it would tie in with other legislation that we're now putting through? Would that be sensible?
That would be my point, that there's now a mix because of the passage of time where I suppose European case law is fairly clear about the age of a child, and some of our legislation differs from that because of history. It would be clearer if that was consistent in terms of the simplicity of operation, for sure. There is another connected issue round about the rights of suspects whilst in custody, whether children or adults, round about the use of the appropriate adult scheme, and the requirement in the bill for the police to ensure that an appropriate adult is made available for certain vulnerable suspects. And I know that others have expressed a concern in some of their written submissions, and I would wish to emphasise our concern that whilst that's absolutely the right thing to do, it's consistent with common practice. We've seen a huge increase in the number of appropriate adults that have been requested, I think because of an enhanced understanding in terms of the circumstances where it's fair and proportionate to do that. But the schemes that are in place, and they're very different across different local authority areas, are creaking at the seams. And to impose that condition on the police without there being any statutory requirement for there to be a scheme in every area is going to potentially leave the police in a very difficult position, where I don't think it should be our responsibility to supply that independent person.
Thank you. Any other comments? So we'll put that. I'm trying to move on because I'm aware of the time. We've got another panel of witnesses. Questions, please, and please. Yes.
Very brief supplementary on
Yes,
that, please.
okay.
And it is about operational policing. It is the case, setting this legislation aside, that there are huge challenges for the police service anyway in identifying it. Sometimes it's after the event people will come forward and identify themselves as being vulnerable. Is that not the case?
That could undoubtedly be the case, although I think there's never been in place more checks and balances at the point that somebody would be either questioned or detained, to ensure that we do everything we can to identify that at the time that we're going to need to call on the services of somebody to offer that support and independent advice.
I now need to ask about, just for completeness, the Police Negotiating Board for Scotland. Is this all absolutely fine, no problem? Any comments you would like to make about what's in the legislation? Happy and unhappy about, Mr Gillis?
Well, the comment from Police Scotland would be that we welcome the creation of the PNB for Police Scotland. I think we're certainly pro-collective consultation with the opportunity for staff associations to get round the table to negotiate on key matters as set out in the legislation. I think there are elements of the detail which we've provided submissions on which can be developed. For example, from our perspective, at this point in time, specials aren't included in the legislation, and we've raised the question why, if specials are afforded the same equipment and clothing as other officers, regulars, then why isn't that more specific? But in general terms, we're very supportive of what's being proposed. It's actually operating informally at this point in time within Scotland, and it's a case of taking that forward.
The SPF and indeed the wider staff side of the Police Negotiating Board Scotland Standing Committee, as it stands just now, welcomes the creation of a new Police Negotiating Board in its own right for Scotland. The fact that the PNB across the UK in its own right is being disbanded is, in our view, abhorrent and fundamental disservice to the flying women and men of the police service in England, Wales and indeed Northern Ireland, whose own position currently remains unclear. We have submitted a fairly comprehensive response to the separate consultation on the PNB for Scotland. That closed on Friday of last week, and I appreciate that the vast majority of the members have probably not got our responses around them. But there are some issues with the proposals. I mean, I know it's not a debating point between myself and John at this moment in time, but the issue of uniform and equipment is, in our view, not something that should be negotiable. It's either something that you provide or something that you don't. And the reason that we don't cover special constables is because it's about terms and conditions, effectively pay and rations, and until such time, or unless such a decision is taken that they want to salary special constables, then we see no reason why they should be covered by the provisions of the Police Negotiating Board. The Cabinet Secretary has also made some very helpful comments about the shortcomings that currently exist in terms of an arbitrator's decision or an arbitration tribunal's decision when there is the ability for the respective Secretaries of State or indeed the Home Secretary to effectively overturn that, because an arbitration tribunal decision is binding on one side only, and that is the staff side, and we consider that to be manifestly unfair. And indeed, there is an indication from the Cabinet Secretary that at least as far as pay is concerned, that he would be willing to have pay matters binding. But of course, the legislation is structured in such a way that whilst the Cabinet Secretary can bind himself, or indeed a future herself, they do not necessarily bind Parliament. And that is something that we would need to make sure that is addressed, because the binding of an individual, whilst you might have confidence in that individual's particular ability to perform the job, is not the same as having binding arbitration in its own right. And that is something that would need to be addressed during the main provisions of the Criminal Justice Bill in its own right. But there are many lengthy additional elements that are contained within our response to the bill. But on the whole, very supportive of the notion of it, albeit we see some shortcomings that can be improved, because I feel it would be a massive loss of opportunity if we simply take what has been a broken system, or certainly a broken system in recent years, dominated effectively by the Home Office, who have been there for no other purpose but to make sure that the government's agenda is not breached. If we simply take the model for that and replicate it in Scotland without trying to overcome some of the weaknesses that exist in the past.
Somebody else wish to, before I take in John, Mr Diamond, do you want to, from your member's point of view? No?
Sorry, we're not covered with PNB.
Right, John, you've got a question.
Thank you. It's just for the panel. Are the chief officers going to participate now, Mr Graham?
Chief officers are covered by the arrangement at this point in time. SCIPOSA, which is the Chief Officers Association, is represented at PNB currently in terms of its informal establishment, and we'd see that continuing as one of the 3 constituent staff groupings for Scotland.
So just for the avoidance of any doubt whatsoever, all police officers in Scotland's terms and conditions will be dealt with by PNB Scotland, is that?
Chief Officers, Superintendents Association and Federated Ranks are covered.
Thank you.
Yes, sorry, Mr Seal.
That is absolutely correct in terms of the proposal that is being drafted. One thing that remains unclear, though, is whether the Chief Police Officer Staff Association is to take the view as to whether it should fall under the ambit of the Senior Salaries Review Body. And certainly it is the view of my association, and I know that David will speak for himself, that if that was to happen, that would be a fundamental issue for the Police Negotiating Board in Scotland, because once you lose the buy-in from the very senior officers in the service that the negotiating mechanism is the right way of dealing with pay and conditions across the whole service, you lose a very, very fundamental link with making sure that there is a common, negotiated, fair approach to terms and conditions, and the possibility of creating an elitist approach by a view of inferring that you're better than the rest is something that we think would be particularly damaging.
That said, I'm now, thank you. If there's anything you wish additionally to give, given the pressure of time, please feel free to write to us as a committee, write to me as convener, and it will be circulated to the committee, any other points that perhaps we should have pursued. Can I thank you very much, and I'm going to suspend for 5 minutes, although I'm now learning it's arrested but not officially accused. I must get that into my head, that that's the expression. Thank you very much. you very much. And we're back on, and our second panel of witnesses. And I welcome David Harvey, Director of Serious Casework, Crown Office and Procurator Fiscal Service, Grazia Robertson, Member of the Law Society Criminal Law Committee, Law Society of Scotland, and Ritchie, President of the Glasgow Bar Association, and Murdo MacLeod QC, Faculty of Advocates. And I welcome you all here. Thank you for your written submissions. And again, committee, same areas as before, the same parts of the bill. And just questions, please. I know you're all ready with your pencil sharpened. Who's got a sharpened pencil? Margaret.
One area we didn't cover in the last section was the authorisation for keeping in custody, specifically the Faculty of Advocates and Law Societies recommendation or consideration that authorisation for keeping a person in custody should be by an officer of the rank of sergeant as opposed to a constable. Could you perhaps talk a little bit to why you consider that should be the case?
And if just indicate to me who wants to respond, I'll make sure. Mr MacLeod.
I should respond to that.
Yes, of course.
Ms Mitchell and Convener, I wonder if I may just start by saying that the faculty is grateful for the opportunity to give evidence and to assist the Justice Committee with its scrutiny of this bill. And with regard to the bill itself, we support the simplification, clarification and modernisation of the law of arrest and detention in Scotland. We have certain comments that are in writing and hopefully we can discuss to some extent about 14 of the 56 sections in Part 1, but in broad terms I repeat that the faculty welcomes the thrust of the reforms set out in Part 1 and, as it were, the general direction of travel, and any criticisms are, I hope, to be largely constructive. Turning then, if I may...
Criticism from the faculty is constructive, notwithstanding other comments that we made by other witnesses.
Yes, and with regard to the question which I think is directed to Section 7 of the bill, I think from recollection the proposal is that it should be someone of the rank of constable who determines whether the person, it should be the arrestee, should be kept in custody. Well, we simply say that when one considers, for example, Section 9, which is the review after 6 hours, which is another innovation, that is the continuing detention, as it were, is to be reviewed by someone of the rank of inspector or above. So it's quite a leap from constable to inspector. So quite simply we're saying, why not have a sergeant looking at it, who would of course also be senior to the rank of police constable, rather than having a police constable looking at what another police constable is doing.
To be a certain consistency in that. Do any of the other panel?
Yes, sorry, just to ask. Ms Robertson.
Yes, thank you. Again, like my colleague, the Law Society does welcome the opportunity of addressing you today in the terms of the Criminal Justice Bill. Taking specifically that point, yes, I think for continuity, the duty sergeant, as he's known, currently takes decisions with regard to keeping people in custody, releasing people on bail undertakings. Therefore, the sergeant has that responsibility at present for those tasks, and it felt to ourselves it would be more appropriate for someone of that rank to have these obligations as stated in terms of the bill.
Any other comments, Ms Ritchie? Sorry, Mr Harvey first, yes.
Very briefly, Chair, if I may assist, it's obviously a matter directly for Police Scotland, but it's my understanding, as my colleague has said, that in respect of primary custody sites, those decisions are taken by custody sergeants. At secondary sites, which are sometimes opened up if there are large numbers, the more senior officer may be simply a constable rather than a sergeant. But as I understand it, the decision is referred over to a custody sergeant. So at present, regardless of whether or not the senior officer is a constable or a sergeant, the decision is always taken at sergeant level. So I wonder whether, and it would be a matter for Police Scotland, but I wonder whether actually the faculty proposal would actually have any significant impact on Police Scotland's current processes. It would appear that in practice it's done at sergeant level, regardless of whether the person is at the site or not.
By a constable, and that isn't done at present. Indeed. So I think it's a fair point to have raised.
Indeed.
Yeah.
Ms Ritchie, would you wanted to?
I just wonder whether in practice it's perhaps a bit of a notional concept, but in a busy police station on a Saturday night, I wonder how many times, no matter what the rank of the police officer is, whether they'd be likely to overrule the investigating officers. I think it's probably likely that they would take their lead from those who've been investigating the case in any event. And I wonder how many times those who bring a person into custody by arresting them, their decision or their thoughts on whether the arrestee should be retained in custody is likely to be overruled. At present, I'd be surprised if it was very often.
But nonetheless, would you welcome the change that it should be someone of, a sergeant, duty sergeant kind of rank?
I think it should not be someone of similar rank. I think it should be a higher up sergeant or inspector.
That's helpful, thank you.
Elaine, followed by Roderick.
Yes, I was wanting to ask you about your views on the 12-hour limit, because the Police Scotland believe that the current capability of extending to 24 hours should be retained in exceptional circumstances, whereas other organisations are arguing it should not. And indeed, I believe the Edinburgh Bar Association suggests we should reimpose this 6-hour limit. So I wanted to invite reflections on that issue.
Well, the faculty is content with the 12 hours and welcomes Lord Carloway, I think who started this off, his reining in of the 24 hours, which was the response to CADR in the 2010 Criminal Procedure Act. I think if one looks carefully at the responses, one, I think, sees a thread, namely that 12 hours would be sufficient. And of course it's 6 hours and then a review of 6 hours, and one would imagine that would be pretty readily granted by a senior officer of inspector or above in the circumstances. All I would say additionally is that, of course, they still have 28 days, if necessary, to release and to impose conditions, which, if allowed, and we'll come on to discuss these, I'm sure, can be quite stringent. So it's not the end of the road as far as the police are concerned.
To comment. Ms Robertson.
Thank you. Just to say that obviously as the Law Society has stated, I think our position is like the Edinburgh Bar Association, that 6 hours we feel is sufficient and proportionate for the police to carry out their tasks. We do recognise the arguments in favour of 12 hours, and we do welcome the fact that the bill proposes to at least curtail the period of time to one of 12 hours as opposed to extending it further, in recognition of the fact that this is the restriction on someone's liberty, and as Lord Carloway has said, it should only be taken in steps where there is absolute necessity for that. However, the Law Society echo the position of the Edinburgh Bar Association and feel that 6 hours is appropriate.
Mr Harvey.
Thank you, Chair. I think it's apparent from the Crown's written submission, which the committee has, that given the very small number of cases that we're talking about, I think Police Scotland indicated that looking at 0.4 of all persons detained, that there is a case in the most serious types of investigation involving the most complex investigations for there to be the possibility of longer than 12 hours. And again, I think that the Police Scotland submission in relation to comparators in other parts of the UK is a helpful one in that respect, in terms of simply those very, very top-end investigations, which it would appear on the face of it, given that the current powers that are available to them up to 24 hours, there's no suggestion that that's being used excessively if the point is that it's only 0.4, which I think they say equates to one person every 2.5 days. But in those instances, they have found that necessary and proportionate to further the investigation.
This is indicated, Roderick.
So I should begin just by referring to my register of interest as a member of the Faculty of Advocates. My question, the first question, is of a general nature. I wonder what whether the panel thought that the bill as drafted is keeping up with the thrust of developments on the European Convention and the European Court of Human Rights case law, or are there any respects in which the panel believe we might be not quite keeping up to speed?
I think that it is. It's certainly making attempts to do so, but I think we have a concern that I think that the CADR case, it didn't provide a suspect with some sort of added advantage of having a right of representation in a police station, and I would be concerned that the committee thought that there was anything other than a minimum protection which is required to secure a fair trial. And what I would be concerned about is that there might be some idea that there was a rebalancing exercise was required. If suspects are obtaining the advantage of a solicitor when they're in custody, then as a result of that we have to do something like remove the requirement of corroboration, which I appreciate is a separate issue. But it's not about that, and I would just ask the committee to be aware that the rights of the suspect in the police station are minimum protections required in terms of ECHR, rather than something that needs to be offset with some disadvantage effectively.
Sorry, I beg your pardon, Ms Robertson.
Sorry, if I could just say from the point of view of the Law Society, obviously the ECHR provisions were well within our minds when we were forming our response, and that is indicated to some extent in the comments that we have made with regard to the provisions of the bill. But I would commend the committee to the paper which I know you've received from the Human Rights Commission, the Scottish Human Rights Commission, which clearly is very much focused its comments with a view to the ECHR provisions. And I think that's very useful in seeing how that fits in with the bill as it currently stands.
Mr. Harvey.
Just very briefly, I think that rather than looking at this as an incremental response to recent case law, I think this should be regarded as an opportunity to do precisely as Mr. Campbell describes, which is to try and make sure that the system which we're all seeking to operate is a just and fair one and will be convention compliant going forward. And so we would welcome, for example, the phraseology in for example, section 10, which sets out and makes direct reference, I think, reading across to some of the provisions in Article 5, the checks and balances that are included in relation to judicial intervention and review at particular stages during the investigation process, which are new. You asked whether or not I felt that it was in its entirety, and the only thing that I would pick up on, and I missed the beginning of the earlier submission, or the earlier conversation involving the panel, but I do know that there were some issues in and around the powers of a constable and the fact that it's necessary once someone has been arrested or detained or whatever it is that we eventually decide to call it, has to be taken to a police station. And I do wonder about that in circumstances where evidence comes to light prior to getting to the police station that actually it's the wrong individual, or etc. And I wonder whether or not actually the strict terms of as currently drafted might mean that someone has to be taken to a police station, albeit at that stage they are no longer under suspicion.
Yes, of course, Mr. MacLeod.
Say that in terms of section 5.3, for example, there is reference to the a European directive. That's about the letter of rights, which this committee will be familiar with, but also in terms of the European directive on rights of access to a lawyer, which is coming in shortly, although Britain may not opt into it. It's not clear, but I think there have been indications that we may attempt to follow the majority of its implementations. In terms of both of these directives and in terms of CADR and the lessons learnt from that, the bill, or this draft of the bill, does, I think, attempt to fall into line with these directives. And can I also say that I would agree with, and I think it's an important point she makes, that the giving of rights to the accused, and, for example, a reduction in the amount of time that they can be in custody, is not some quid pro quo for the abolition of corroboration. These are standalone provisions that, in the faculty's view, would have have been enacted in any event.
Could I just ask a supplemental, just because you mentioned the letter of rights, any kind of brief general thoughts on how the letter of rights provisions are working at this early stage?
Well, not for me. They only came in July, but the point I would say, if I may, is just to, and it's a point that we've made in our written submissions, is to direct the committee's attention to section 5.3, which is the government's attempt to say that the terms of the letter of rights directive must be implemented, in that the person, the arrestee, must be provided as soon as practicable with information, verbally or in writing. Well, we would say quite strongly on that point that it should be verbally and in writing. It is an unfortunate but inevitable consequence of the I suppose, the state of Scottish society, that many arrestees or people brought into custody have literacy problems. Also, they may be very frightened as to what has happened, and it is only fair, it seems to us, that rather than simply being handed a letter with the 7 rights on it, the rights are also read out to them. It won't take long, and after all, that's what happens when you're cautioned by the police, that you don't have to say anything.
It's not the case that you have to understand what's
Yes.
going, whether it's literacy or language problems. You have to understand the process, or the process could be at fault.
Precisely.
I think there's studies that show that information which is given verbally and in writing is very much more easily understood, and I think that that's very important if we're actually trying to properly protect the rights of suspects in a meaningful way.
Chair, it's about detention and arrest. Do you want to go into that just now? Is that?
The only thing I was going to go on was the section with... I'll let you do that, then after something
Okay,
about.
thank you very much. I don't know if you heard the previous evidence, which basically got into a really, really good discussion about detention and arrest. And I know that the Law Society of Scotland are questioning whether there's actually a need for a change, if it has been demonstrated. And I believe that's what Callum Steele had also said. I just want your thoughts on that. I mean, certainly I can't quite get my head round the need for either change.
I was interested to hear the police officer Callum Steele's comments and also the response from the committee members with regard to that. I mean, I personally feel that someone not officially under suspicion or investigation, or whatever the precise term was, is... Well, I try to remember it and then I forget it. If we're trying to simplify and modernise it, I find that concept particularly difficult. And I do know that Lord McCluskey said that law should be kept simple, if only for the benefit of the profession, and I know he was making that as a joke. But I think there's a very real point. We as solicitors have to explain to our clients what this all means, and I think to say to someone you're not officially in that category, not officially accused, however, they may then undergo an interview where questions will be put to them which will effectively accuse them of various offences, and it becomes very difficult to know what their status is. And obviously you'll see from the written response from the Law Society that I was very sympathetic to the points raised by Callum Steele, that I couldn't see, or the Law Society couldn't see a reason for this change that really made sense in the sense of simplifying. I could see where it changed matters, but I couldn't see where it simplified or necessarily modernised it, because the system as changed in the light of CADR seems to be bedded in well and seems to be working well, I would suggest.
Yes, the comments, yes.
I would agree with that. I wonder whether it is actually necessary to legislate, and whether or not changes or improvements could be made, could be achieved through recommendations or Lord Advocate's guidelines. And I think that the committee should obviously think about the law of unintended consequences, and I would be concerned that introductions are just brought in the form of the bill and then forgotten about. I think there has to be some sort of meaningful review, because a lot of how the bill, if it came in its present form, how it worked would be very much dependent on the manner in which the police enforced it. And I think there are a number of consequences to bringing in the bill, not least of which the legal aid system. My understanding from the response from the Legal Aid Board is that there's no real parallel at the moment for all this pre-charge work. The trigger for the most part for legal aid is the service of prosecution papers, and any change to that, as I understand it, will require primary legislative change. So there's a lot of factors which would be easy to simply overlook with the vigour to bring in the bill to be ECHR compliant.
I wasn't about to overlook it, because I was looking at section 24 and all the times and the right to have a solicitor, and was going to ask, but we'll leave that, come back to it on the implications for the Legal Aid Board in cost and in resources and firms and so on. So I think we would have come to that. Sandra, yes, no, others on this matter of do we need it in the first place? Are we not better off where we are? Mr. MacLeod.
Strike a different note to that of my two colleagues, and I should caution what I say by, of course, recognising that they are meeting with clients on a regular basis and discussing them, maybe slightly one step removed, as it were, from where I and my colleagues come in. However, the faculty believes that this does simplify matters. And again, my colleagues might have a better take on this, but might it not be the case that if someone is told they're not officially accused and then their status changes and they're actually officially accused of something, that is actually simpler than saying, right, you're detained under Section 14, or you're here by virtue of a statutory warrant, or you're here by virtue of a common law warrant. So I would respectfully suggest that this actually simplifies matters. And the further point I would make is that following CADR and the sequelae to that, it seems to me that the distinction between detention and arrest is almost academic anyway, because you can have your solicitor present with you now, or you're entitled to that during detention as well as afterwards. So I would be, or we would be in favour of the adoption of these terms.
Mr. Harvey.
Thank you, Chair. Just in terms of the issue as to whether or not there's a requirement for simplification, I brought along with me just a couple of pages from Renton and Brown, which many of you will be familiar with. And I pause simply to observe that the first comment under common law offences is it's difficult to state clearly the common law regarding arrest without warrant. And then when one looks under statutory offences, it starts with, it's not clear what common law rights the Scots Police have to arrest without warrant for statutory offences. So that's the starting position as far as the main textbook is concerned in terms of criminal procedure. So I welcome, and the Crown welcomes, the attempt to try and make this procedure more straightforward. I do take the point that was raised earlier in and around perception and use of language in relation to sections 1 and 2, but the underlying aim of section 1 and 2 is to provide for one system where if there is reasonable suspicion, then an individual has a particular status. And so therefore in that endeavour, I support the aims of the bill.
Of course, I've got John Finney next, then Margaret.
Thank you, Chair. You did, for me anyway, you did hit the nail on the head when you said perception. You've heard what went on with the previous panel. But I was interested in what Ms Robertson had said when you mentioned the fact, and I keep saying this, I'm not a lawyer, I have a legal background, but you were saying that it was to make law easier for people who are engaged with it, whether it be witnesses or victims or accused even. But you said something quite interesting, I thought, was when you were... the one that caught me was the fact that you had to explain to the people, basically these are their rights and they may be accused of certain things. Could you perhaps expand on that and what difference it makes at the moment they are being detained, and if this comes into fruition they would be arrested? Can you explain to me what you meant by that when you were talking to your client?
Simply that the procedure at the moment is explained to the client. You are detained and you can advise them of what obligations they have, what powers the police have in relation to that. And then there is a natural change in that person's status after the period of detention. They will either be released or they will be charged, or they may hear further simply released and the Procurator Fiscal may take a decision, and that procedure is all well established, and there is a flow through that you can explain to the client. To say to someone you're now of a status of not officially accused, however you cannot leave the police station, your power to leave is curtailed, you will be asked questions in the course of a police interview which will necessarily make accusations against you, because the whole purpose of the interview is to say, well, at present anyway, for police to say you are here in connection with a charge, for example, of assault now, and then accusations are presented and he's asked or she is asked to comment on those. The person can choose not to, but they can choose to comment. So the phrase, the term seemed clumsy at the very least, and the purpose of having it, our view would be, well, we would consider, does it serve a purpose? Does it enhance matters? Does it progress matters? And we couldn't see from those provisions where matters were progressed or enhanced on the current system, given, as I say, that it had changed relatively recently and improved in the light of the CADR decision. Procedures are now in place that, in our view, seem to work well.
Anybody else wish to comment on this, which seems
I wonder if I could,
troubling the committee, I think.
I appreciate I may appear to be excessively critical of some parts of the Act. I'm trying to put forward the perspective from behalf of the Glasgow Bar Association and our members who are effectively at the coalface and going into the police stations really on a daily basis, and I do that too. And I wonder, to answer the question, just to look at, for example, section 5, information to be given at a police station, and that's information to be given to a suspect, an arrested person. To me, if we looked at section 5, subsections 1 and 2, this seems to be drafted in a form which is incredibly and excessively complex, bearing in mind that section 5 relates to information to be given to an arrested person whose solicitor has not yet arrived at the police station, because this is telling them effectively that they have the right to a solicitor. And I appreciate that many suspects won't go home and read the law, but if this is to give a suspect an understanding, if this is an improvement, this bill is an improvement on the present law, and a man in the streets to look at section 5 and be told, here's your rights if you're an arrested person, then if anybody can assist me to explain to somebody in layman's terms what that means, and I deal with legislation every day, I find that incredibly and unnecessarily complex. And I just wonder whether bringing in legislation which is so complex could on any view be deemed to be an improvement. Section 14 provides fairly straightforward rights which we can advise clients on. That's present detention for up to 12 hours, provides statutory formulation of the rights that a suspect has, which are very clear, give your name and address and your date of birth. But as I say, section 5, this is information to be given to suspects, and I have to say I can't see how that improves the situation.
How much of this bill is introduced would you delete? Sections, which sections would you suggest? I mean, seriously.
I don't think deletion's the right word. I think rephrasing and in clear terms. Basically, section 5 needs to lay out that a person has a right not to say anything, and they have a right to access by certain people, and name who those people are. The cross-referencing just makes it very difficult. If you were to hand that section to a member of the public walking past the building today, they would be none the wiser as to what their rights were.
I take it to substitute word for arrest, detention makes it a reappearance, making it, I mean, simply looking from a person's point of view, from detention to arrest is a watershed. You know you're moving into a different zone, but to use the term arrest and that phrase that none of us can remember, and then change it to arrest with that other phrase, then it is difficult to follow.
I've perhaps strayed from the original issue of whether...
Which I think is what...
I appreciate that, but as I say, if we're looking at giving suspects rights, section 5 is about what their rights are. And if anybody here can explain, assist me in just putting that in a nutshell.
What I'm asking is, should we be putting in the word detention in parts, substitute it, that the process itself may not be at fault entirely, but the terminology is makes it complicated. So if you put detention and information given on detention, then it begins to sort of adjust itself a little. I'm putting it very broadly, but is that
that's not really the point I'm making.
Okay,
I think it's a different issue whether or not we need to change the present situation, which is a suspect is detained,
yes,
to whether a suspect has to be arrested, and that's an issue where I think Mr MacLeod's indicated that the faculty think that's a good move. Mrs Robertson's taken the Law Society have taken the view that it's perhaps not necessary. I'm suggesting that it's perhaps not necessary because the detention procedures
has changed.
It's fairly clearly understood at present.
No, the only extra point I was going to make was that there's a criticism that the law is very full of legalese, and I think when you look at words, someone being detained, someone being arrested, I think that's quite easy for people to understand, and we're always striving that the law should be more understandable.
Mr Harvey, then I'll take Mr MacLeod.
Thank you, Chair. Just to clarify, and again, without wanting to go back to the issue of definitions of between arrest and detention, I think just dealing specifically with the Section 5 point that was raised, and appreciating the way it's been drafted, it cross-refers to a number of different sections, but as I read it, the person is either going to be told verbally and or, depending upon whether or not the faculty point is picked up in terms of the legitimate point of how people understand information and how they take it in, but they'll either be told and or given something in writing which says you don't need to say anything, you have right of access to a solicitor, and if you happen to be of a particular age, then you can have the right to another person to assist you. And just picking up on the final point of subsection 3, these are the kinds of things that I would have thought from a convention perspective and also from an EU perspective. And indeed, if any one of us were found ourselves in a situation where we're in a police station, which we would want to know. So I would have thought that the intent is unobjectionable, which is actually to say to people, before the solicitor even arrives, this is the basic information that you need to know about what your rights are. And so I think that that wouldn't be a section that I would suggest needs to be deleted. I think that that is actually one of the key foundations that makes this a convention-compliant bill.
Sorry, I'm looking at section 26, yes, sorry.
I say I've got a degree of sympathy with my colleague, Miss Ritchie, about, you have to flick through the Act to get to the relevant qualification or subsection. However, many pieces of legislation, unfortunately, are like that. Even the 1995 Act, which is our day-to-day guidebook, is full of alterations and amendments. And also, playing devil's advocate, if I may, it's not a point we've made in our written submission, the arrestee, or whatever you call that person, will have their letter of rights, which sets out all of their rights. And I'm not sure if, and accused again, I'm not at the coalface, but would be poring over the Section 5 of the Act in any event. They just want to know what their rights are, and would they not derive knowledge of that from the letter of rights which they are now given as of 2 months ago.
Might also be worried what's going to appear in the local paper with the terminology. Yes, Margaret.
Yeah, just specifically to Mr MacLeod and Mr Harvey, who have both indicated they're in favour of the simplification with new provisions for power arrests. Do they have any concern that well, I can only assume it's an unintentional consequence of these new powers of arrest definitions is they prevent a crime, or the power of arrest to prevent a crime isn't now explicit in the bill. Do they have a view on that? And that's particularly a duty under the new Police and Fire Reform Scotland Act that constables should be looking at preventing crime. Either?
I'm very happy to speak first. I don't know what the intention is in relation to that, and I don't know whether that is by way of omission, but certainly from a public interest perspective and a convention perspective in terms of the rights of the public in a broader sense, I would have thought that that would be a crucial element in terms of police being able to intervene at the appropriate time and if necessary, to prevent the criminality actually taking place. And as we know, there are any number of occasions where the police may have evidence of conspiracy to commit an offence that has not yet taken place, and so therefore it would seem sensible that the power of arrest or detention or whatever it is eventually called would apply in those circumstances.
If that wasn't included in it, would you then shift your view from being in favour of the simplification to supporting the status quo?
I suppose that what I would seek to argue as a prosecutor is that if it was a conspiracy, then they were already committing an offence and therefore they could arrest. And seek to work within the terms of the legislation as drafted.
Or indeed an attempt to commit an offence.
So there would be ways of arguing it, but I agree that it's not explicit there in terms of...
But surely the fact we're even having this debate defeats the argument this is simplification.
Well, what I said was I supported the intention to simplify, and what I also indicated was that I thought that there was some informed discussion earlier about perception and use of terminology. But in terms, going back to what I quoted earlier about the Renton and Brown position and the position overall in terms of common law arrest and how that associates not only to common law offences but to statutory offences, the key textbook itself acknowledges that it's not a straightforward position. So the attempt to simplify is most welcome, and I think that this the bill as drafted goes a long way there, but part of the reason why we're having this process is because there are opportunities to refine the thinking.
Huge distinction, a very welcome one, you know, the attempt to simplify without actually stating that it actually does that. Mr. MacLeod?
I've nothing to add. I note that it's not something that we had addressed previously, but I noticed that, echoing to some extent what Mr. Harvey says, that subsection 1 of section 1 says that the person can be arrested if they're committing, if they have committed or are committing an offence. So there is a power there for the police to stop someone in the process of committing a crime. And as Mr. Harvey says, wearing his prosecutor's hat, if someone is conspiring to commit a crime or even attempting to commit a crime, they could be arrested at that stage. But I take Ms Mitchell's point, though.
Thank you.
John Finney, followed by Alison.
Panel, it's about section 23, information to be given before interview, and in particular the evidence we've received from the Scottish Human Rights Commission, who welcome the requirement for the information to be given in arrest set out in section 3 of the legislation. However, they go on to say this: however, the Commission is of the opinion that the suspect and his solicitors should be informed prior to interview of the content of the reasonable grounds for suspicion. I personally concur with that view. Do you have a view on that?
I would concur with that view. Again, looking at the coalface, my understanding is now that some information can be given to solicitors when they attend at the police station, but I'm not sure if that is codified anywhere. But yes, that would seem sensible. But also, if I may, there is one other aspect of that section, which is subsection 2, about the caution which the faculty finds peculiar, where it is said that not more than 1 hour before the commencement of the interview, the person should be cautioned that they needn't say anything. Well, we submit that that should be amended to say that not more than 1 hour before and at the commencement of any interview, because currently it's as you'll all be aware, at the beginning of the interview, many of them are tape recorded, the arrestee would be cautioned and that they didn't say anything. Sometimes that caution is repeated, so that must happen at the commencement of the interview as well as not more than 1 hour before.
It strikes me that the caution that the person's under no obligation to say anything, and that's section 23(2), in actual fact only states half of what the present common law caution is, which is no obligation to say anything, and anything you do say may be noted and may be used in evidence. And I don't know if that's simply an omission, but that certainly at present, in the present law, if that was to be the limited nature of the caution, just to advise that they're not under an obligation to say anything, then I would suggest that the interview, the answers to any questions given would be deemed to be inadmissible as unfair. So I wonder whether there should be that caution should be added to say that there's any information given may be used against the person.
Yes, just to say that the Law Society view with regard to the information to be given, to make the interview with your client meaningful, you have to have a certain amount of information in order to be able to advise them. And that's when the interview then, with the private consultation with your client, then has some meaning and some significance and serves its purpose. Clearly, if the solicitor has no information or very little information, then that private consultation cannot have any great assistance to the client, and to a degree will not fulfil its purpose of having legal advice if you can't properly advise them. So some amount of information is essential. I have to say that from a practical point of view, as a practising solicitor, when I go to a police station, I ask police officers for information, and I usually am provided with at least sufficient information to at least give some meaningful advice to my client. So I don't think that has been a problem to date. And with regard to the cautioning, certainly on a practical basis, when you attend for interview with your client, the caution, as Murdo has indicated, is repeated on tape for the protection of everyone, for the protection of the police officers, to ensure that there is evidence that they are performing their function properly. And it's also a reminder to the client of that very important protection. You need to say nothing, but if you do, it may be used in evidence. So the practical situation is working well.
I've found that the practice varies with different police officers as to how much information you're given. I have been in situations recently when the police officers have simply stated that, well, you'll become aware of what evidence we've got through the questions we're going to ask. Now I have had that fairly recently, and that, to my mind, is pointless. My pre-interview consultation, as Grazia's indicated, it becomes effectively meaningless, because my advice would have to be to the suspect to make no comment on the basis that I'm not being given any information as to what the case against them is. So it does seem to vary. So full disclosure would assist.
Can I just say, and I'm not trying to jump onto the next bandwagon and mention corroboration yet again, but again, if you're looking at the bill as a whole, if that, for example, if that provision were to come in, corroboration were to be abolished, it may well be that our advice may require to change in that pre-interview consultation, so that there are a lot of factors that in due course would indicate that a certain amount of information would be required from the solicitor for him to perform, or she to perform her role properly.
Big bite at corroboration later, no doubt.
Not by me, but I'm
well,
sure my colleagues will be here.
I meant the various professions as well as others. Margaret, sorry, I beg your pardon.
I may just come in there. I think the provision of information to arrestees is of crucial importance and is to some extent, in our view, neglected. For example, with regard to investigative liberation, it seems to us that the on being liberated at that time, when a person isn't officially accused, they should be told, in essence, what Grazia tells us that she is being told by some police officers. That should be on a formal basis. The arrestee should be told what it is that he is suspected of having done and what the evidence is, because without that, the appeal to the sheriff, which is provided for at 2 stages, is really to be heard in vacuo, with no understanding on the defence's part as to what the evidence is against the arrestee. So we would, I think, following on from what Mr Finney says, I think the provision of information to the accused at various stages of the process must be catered for.
Before I move on, can I say to the committee, I'm mindful to drop item 6 in the agenda so we can give a really good cross-examination of this panel and deal with the other items on our agenda. Next week isn't too bad. We've got 2 panels and we can do our draft report next week, because I'm mindful also that many of you are in the debate this afternoon, probably starting about 2:10. Right, you're happy about that? So I'll do that when I come to it. But just to alert you, you're not to panic. Don't panic, as somebody once said. John, you've got a supplementary.
It was just to clarify a couple of points with the panel. The issue of the caution there, I don't know if that, is it your view it would require to be on the face of the bill? Is it process-wise, is it not something that there could be a series of cautions throughout the process of an accused being in? And further to that, if I may please, we heard earlier about Lord Advocate's guidelines on retention of people in custody. Is that something that your associations would routinely have been consulted on? Or would there be benefit in being consulted on?
No was the answer to your second point. And the first point, again, goes back to what Grazia said about the, and I think or maybe someone else said, about the ongoing process. The caution is repeated at various times. For example, if there's a rest break, you'll be familiar with that yourself. The caution is then provided for. But this provision, as it is, just seems to say that the caution is provided not more than 1 hour before the interview. So it seems to us to be very curious.
If the bill's to improve the status quo, then I could see no reason why they wouldn't simply state the full caution in the terms of the Act. It seems fairly simple enough.
There might be some people that have a sort of jaundiced view of the Scottish Human Rights Commission's involvement and this being one-sided. Would be your view that the interests of justice are better served if there's equitable treatment?
Undoubtedly, and it cuts both ways, because if someone isn't properly cautioned and isn't following the proceedings and isn't reminded of their statutory duties, then there may be an appeal in due course. So I think it's in everyone's benefit that the rights are reiterated.
There's no great advantage with suspects being acquitted on what are deemed by the public to be technicalities. It's not something which is particularly satisfactory for any party.
I would agree.
Chair, certainly I on reading that section, didn't envisage that was in some way going to mean that there had been a caution administered off tape, for want of a better phrase, and if that was what was envisaged, then that wouldn't obviously be helpful from anyone's perspective. So looking at this as a process whereby the individual is going through a number of stages. I had read this as and when you're being told that you can have a solicitor, you're also reminded at that stage that this is the position. But equally, I would have expected that at the commencement of any interview that was being recorded, that the person would be reminded of their status and the caution.
Thank you. I now have Alison, followed by Rod.
Thank you. Scots law has traditionally prohibited any questioning following police charge. Section 27 of this bill introduces the idea of post-charge questioning, and a number of the people who have submitted written evidence have questioned the value of that, and indeed others have questioned how compatible it is with the right to guard against self-incrimination. I'd be interested in the panel's views on that point.
The faculty is quite relatively relaxed about that point, because I think I'm right in saying that an application for further questioning after the person is officially accused must be run past a sheriff. So there is a check there on any, so it must be justified. So it can't be done on some sort of spurious basis. And with a solicitor present during any subsequent questioning by the police, it seems to us to be unlikely that there is a great or a huge scope for a miscarriage of justice at that point. Subject to, I think it would be a counsel of perfection to say that it should always be done in front of the sheriff. But, and I'm conscious of the fact that I came in at the end there, one of the police officers said that it would be rarely done. But if that wasn't the norm, and one can understand how it wouldn't be the norm with the pressures that the police are under and with their limited time, if they were having to go through this process, realising that they had more time to do it, then it might clog up the courts a little bit if every time it happened it had to be in front of a sheriff. So it's very much a case of, I suppose, we would have to see what happens here. But because of the checks, namely that the application is in front of a sheriff or a judge in the High Court, and because the solicitor will be present and will be able to advise the arrestee or the accused by that stage not to say anything if thought appropriate, we are satisfied that those meet the issues you raise.
I don't see the need for any further protections or safeguards, such as full disclosure or anything around about that.
Well, I think the reasons why the application was being made would obviously be ventilated in court, and of course the defence then and the sheriff, one would expect, would ask about the nature of these further inquiries.
I can't see any need for it at all. I would it could only if exculpatory evidence became available during the course of an inquiry after a person has been charged, that would be disclosed to the defence in any event. And if the accused person was questioned on a formal basis about that, is there a suggestion that a prosecution would simply be dropped if they came up with a response to it? I find that very unlikely. On the other hand, if incriminatory evidence were to be obtained from the accused, then I think there's a question whether that procedure falls foul of Article 6 and the right against self-incrimination after charge. So regardless of the outcome of that questioning, I can't see how it would assist either the prosecution or the defence. It's unnecessary in my view.
Yeah, if I could just say on behalf of the Law Society, I think that's probably reflected in our written response that in principle we are opposed to post-arrest or post-charge questioning. On principle that there must come a time when the Crown must be put on notice that it is their obligation to prove the case against the accused, and the accused can no longer be obliged to facilitate his own conviction, as it were. So in principle we're opposed to that. But equally there's a pragmatic element, and if you read the procedure as it's envisaged in the bill, I know that the police officers, when they were talking about certain aspects of the bill, were talking about how difficult it might be to actually carry out these procedures, how cumbersome the procedures may be, and how time-consuming they may be. Now, this authorisation, as it's envisaged, will involve an application to the court. It states that the person accused has an opportunity for representation. I am assuming that would be by way of a solicitor. It would seem unfair if the person was expected to speak on his own behalf or her own behalf. That again becomes another hearing, another opportunity. I appreciate that Mr. Steele was saying I'm sure very lightheartedly that lawyers are always looking for more business when we were talking about investigative liberation. Equally, I would respond equally glibly that police officers are always looking for more power, and there comes a time where it must stop, and it must be said, well, we will not assist you further. Effectively, you are on your own to prove and to investigate this case appropriately. So I think in principle, but also on a pragmatic level, that what is envisaged, we would submit is cumbersome, becomes somewhat bureaucratic, and will result in us all being back in a police office with our clients, presumably advising them to make no comment in a large majority of the cases.
Thank you. I just before I'm trying to look at costs, because you're talking about all that, and what I can't get my head round on the financial memorandum is the cost of the legal aid board of all this. I mean, they've got figures at page 72. This is the estimated additional costs for breach of the liberation proceedings, 863,000 per annum.
If I could read just a very brief point, you were saying about costings. The other point I was going to make about the questioning is that the police officers were saying it would be used in very rare, very serious matters, but the Act itself talks of before a sheriff matters, matters on indictment. So it's envisaging this power being available for relatively less serious matters.
Right.
Now, the Legal Aid Board, again, we can't comment on what they have in mind by
No,
way
I'm
of
just looking at,
systems.
I mean, they've got it in bits. Well, it's not Legal Aid Board, it's in the financial memorandum, which is what the government has to produce to tell us the cost of this. And it's got at page 72, the slab estimated additional costs. This is just for police or procurator fiscal liberation, additional cost of 863,000 per annum. It's got at page 74, financial impact on solicitor contact line, which they've got a stream of things, the uptake, but their total, their highest is over nearly 2 million. And then if we go on to another page, we find out cost for slab resulting for additional prosecutions, something around high estimate is nearly 8 million, low estimate about 1.5 million. These are big figures.
They are big figures, but I would submit they're probably more guesstimates than estimates, because traditionally when you look back on other estimates that have been made for other provisions, they are usually very rough figures, so the suggest that there might be caution in these
Well, I
figures
was
even
being
being
fair,
accurate.
I said 1.5 to 8, and one of the things, which is a huge range, but there are, what I'm trying to get at is, it seems that there are going to be, on the pressures on the criminal legal aid bill in particular, there are going to be substantial pressures embedded in everything that now has to happen in order to have legal representation at various stages and at various testing stages throughout the process of, as the bill as it's laid.
Well, the Law Society obviously represents not only the public, but its members, its solicitors, and we would be very concerned if there was any pressure brought to bear on solicitors to effectively have their funding cut in a way to enable them to represent their clients and to ensure that they can fulfil their obligations in terms of this bill. And so there is obviously an issue with regard, a concern with regard to the Law Society with regard to how funding is envisaged. Now, I recalled the comments of the police officers in relation to certain elements saying, well, costing shouldn't always be an issue, and I would agree you can't always not proceed with something simply because it may be expensive, but then it has to be balanced up about whether what you're intending to bring in is necessary, proportionate, of value, and assists in the administration of justice. And if there is little value in the procedure, then it has to be weighed up against the potential costs that may have.
Anybody else want to comment on the cost? Sorry, Mr. Harvey, yes.
Just finally picking up on the cost point, and then if I may just address one or two of the earlier points, I suppose that if one looks at the cost of the justice system in its entirety, and if there were to be some benefit in appropriate cases in narrowing down the points at issue for trial, then that in itself may have a knock-on cost saving in terms of matters that are at dispute and are clearly at dispute at trial, if it has been possible to narrow those down as a result of this type of process. So I just mention it that if one is looking at it in costing terms, and this is something that just occurs to me just now, so it hasn't been explored, it hasn't been costed, but one has to look at the entirety as opposed to each individual step. And there may be circumstances where this results in greater amounts of evidence being agreed, etc., etc. And in order to explain my view of that, and taking the point that was raised earlier about the standard advice being not to say anything. I'm not sure that that necessarily will always be the case. For example, if it's a situation where the accused by that stage has given instruction and has an explanation to give in relation to particular evidence, then he or she may take that opportunity at that stage in order to do so, rather than actually have to then give evidence at trial. And that may be a perfectly legitimate tactical decision that is made on the part of the defence to actually provide information that actually it gives either an explanation or creates a disclosure obligation on the Crown, or whatever that may be. So, as I say, I think there are a number of elements to that, and one shouldn't always assume that the advice will necessarily be to say nothing. And finally, just dealing with the point about how regularly or otherwise that this may happen, I have to say that I have some sympathy with my colleagues in relation to the administrative process that might be involved in this, and the same would apply from a Crown perspective and a Shrieval perspective as well. And so I think that we can safely say that we will not be opening the floodgates in relation to these types of applications, not least because when one looks at the criteria, first of all, this is something that has a level of judicial scrutiny, so there are appropriate hurdles that need to be crossed. But Section 27 talks about the seriousness of the offence being something that must be taken into account, and the necessity for this particular step being taken. So that, together with the fact that even at that stage, the hearing, as I understand it, will be an adversarial process where there will be an opportunity for representations to be made. And even if there are, then even if there is then a decision whereby a further interview can be conducted, the parameters for that interview, including even the time of that interview, can be dictated by the court. So there are all sorts of cross-checks and balances in order to make sure that this is something which is done in the serious case when it's necessary to do so, and in controlled circumstances where there is the opportunity for an alternate view to be put. And I would say that there are situations, and I think that ACC Graham highlighted them earlier, where in some of the larger scale investigations, for example, and I think that this was a point that Ms McInnes raised earlier in relation to it just simply being instances where it's new information that comes to light beyond the interview. In the very, very large cases, it may well be that the amount and quantity of information which is available even from the initial search is of such a scale that it's not actually possible to exhaustively examine all of that information and understand its import. So, for example, in some of the investigations in relation to material that's recovered online, we can be talking about many gigabytes of material, and you start getting the comparisons that I'm sure the committee will be all too familiar with, of the if one was to print that out on sheets of A4, then it would paper from here to the moon, or whatever it happens to be. But those types of examples are precisely the types of examples where in modern investigations you have to have a level of flexibility to go back and be able to say, we've now uncovered this information, do you have anything to say about that?
Mr MacLeod, no, let me have
very briefly,
in
in response to Mr Harvey and following up or reverting to the original question about the accused rights in these circumstances, Mr Harvey says that the time frames will be limited by the judge or the sheriff. The faculty has grave concerns about that and feels that they should be fixed periods. Like, for example, the 12 hours, the 6 hours, and the current 24 hours and such like, rather than leaving it to the whim of the sheriffs who may have very different ideas on the matter. And those sections are section 27.6 and section 29.2, and we say respectively they should be, the maximum questioning should be for a further 6 hours maximum, and the period of arrest to facilitate that, to enable perhaps people to travel to the station, should be for 12 hours. And lastly, in response to Mr Harvey's point about this questioning after charge being an opportunity for the accused to put his position, well, we cannot surely rely on the Crown going down this process of seeking to question after charge for an accused to give his version. That should be, of course, you will later discuss that judicial declarations are to be abolished in the later parts, and perhaps more controversial parts of this bill. The arrestee or the accused, call them what they like, must be given the opportunity to put forward a defence. They can't rely on the Crown to give them that facility.
other comments so far before I'm coming back? Come to Alison.
Just more generally, it does strike me with there could be a considerable public expense spent on someone who's not yet been charged, access to a solicitor for questioning and then liberated pending further investigation, questioned again, and that person may never be charged. That's a public expense which might be necessary, but it's perhaps the bill is introducing solutions which are actually creating problems, and I'd ask you to consider that.
Alison, sorry, is this a supplementary? No.
Yes. It's in relation to my.
Oh, yes, because you've been deleted.
This was my question.
I shouldn't have deleted you. Then it's you, Rod.
Okay, thank you. It was really to respond to Mr. Harvey, who said that, you know, we've got safeguards because it's being heard in front of a sheriff. I mean, the current test in the bill as it stands is an interests of justice test, so it seems to me far too wide, and actually Mr MacLeod has since then addressed that and discussed some of the safeguards that we might need to explore, so that's fine.
Just touching on that point, obviously, but if this section is going to be used, I thought participants will be mindful of potential Article 6 implications if it is abused. So there are kind of long stops in there as well. But my principal point was it was on section 25 that when I asked the previous panel, I'd be grateful for the panel's views on the question of 16 and 17-year-olds waiving their right of access to a lawyer.
I heard the question and the response previously, and it does seem curious that a person can get married and join the army on the one hand, but if their age were raised to 18, it was unable to waive consent. However, I think that the faculty hasn't really addressed this point in detail, but it seems to me that on the one hand, the letter of rights draws a distinction between people up to the age of 16 and people up to the age of 18, but if the suspect is availed of the additional safeguard in not being allowed to waive this right, then that is only to the suspect's benefit. And, you know, it's something that we would be quite happy to entertain.
Yes, I think the Law Society's position is that the protection of being unable to waive your right to a solicitor should be given to those under 18 years of age. It is a protection, it is a safeguard. It's not an onerous obligation, and therefore I think that it's appropriate that under 18-year-olds should be given that same protection that under 16-year-olds are given. And even the Act itself talks about the definition of a child as being someone under the age of 18 years. Given the particular vulnerabilities, I think that was commented on by the police, the particular vulnerabilities of people who may find themselves in a police station at that age, I think it's entirely appropriate that they should have access to legal advice. They need not take it, as no one needs to take it, but I think it should be made available to them because it is simply a protection and a safeguard.
So simpler, isn't it? So more consistent than to have something for the 16s and then something for the 17 to 18s. It just seems to me unnecessarily complex. But Mr. Harvey.
Thank you, Chair. If it assists the committee, the matter was recently considered by the Appeal Court in McCann versus HMA, and as a result of that, the Lord Advocate issued guidance that indicated that in relation to 16 and 17-year-old suspects, there's to be a strong presumption that they should not be able to waive the right of access to legal advice. And it sets out various requirements that the interviewing officer must take into account. And the key point being the more serious the case, the less likely it is that the presumption should be rebutted. So the guidance as it currently stands offers perhaps a greater level of comfort than might be foreseen from the bare terms of the legislation as it currently stands. And in essence, it's a rebuttable strong presumption.
Yes, Mr.
May I say something just with regard to section 25? There's another tricky point there, it seems to us, which is the proviso that a person owing to a mental disorder appears to be unable to understand sufficiently what is happening or communicate effectively with the police. That phrase, a mental disorder, is a specific phrase, and in our submission to this committee, it may be very difficult for a police officer without any medical training, without the assistance of a police casualty surgeon, to assess whether the individually arrestee is suffering from a mental disorder. So we would simply urge the committee to take out that clause, which is owing to a mental disorder, because and leaving it with a person is 16 but is unable to understand what is happening, surely, and the police officer will be able to see that, and unable to communicate effectively with the police. Well, why on earth should a person in that state not be availed of this right? And in any event, if they weren't, the evidence would probably be inadmissible. So we say that the committee should urge or should seek to take out the phrase owing to mental disorder. And it also applies, I think, later on in section 33.
I'm going to bring this evidence session to an end because I've still got more to do, if that's all right. If there's other issues you wish to raise as supplementary questions we ought to have asked and haven't, please feel free to write to me. It's conveniently distributed to the committee and will also be on our website. Can I thank you very much for your evidence. We look forward to your amendments. No point just suggesting us what we ought to do. We look forward to drafted amendments, no doubt being forwarded to members of Parliament to put at stage 2 of the bill, and we may see some back when we move on to other issues in the bill itself. Thank you very much. I have to stop because we've got a lot to do. I'm going to move on. Now, without any further ado, given we've got a lot of pressing time, I'm going to move on to item 3. Consideration of one negative instrument, the Personal Licence Training Scotland Regulations 2013, SSI 2013-261. This instrument prescribes a training requirement for personal licence holders and how evidence of compliance with the training requirements is to be demonstrated and submitted by the licence holder. The Delegated Powers and Law Reform Committee have drawn the Parliament's attention to this instrument on 2 grounds. Firstly, on the grounds that the form and meaning of the instrument could be clearer in that Regulation 22A and B duplicates the terms of Section 87(1)A and B of the Licence in Scotland Act 2005. The DPLR Committee has concluded that this unnecessary inclusion is of possible detriment to the clarity of the instrument in the context of its interaction with the parent statute. Secondly, on the ground that Regulation 22, which prescribes the training requirement to be met by personal licence holders, appears to be made by an unusual or unexpected use of the enabling powers. The committee has concluded that the instrument does not comply to users of legislation, how on a practical level they can comply with the training requirements. Do any members have any comments? Are you content to endorse the DPLR committee's views and make no recommendation in relation to this instrument? Do you just want to adopt them?
Happy to adopt but just with a note about drafting issues being raised, I think it's perhaps more pertinent to the next 2 we're looking at.
And I think it also relates to, I think, what Lord Gill said in his evidence about the pressures on the statutory drafters in this. If you're going to churn out legislation, there will be pressures on drafters, and I think they're already exhibited. Thank you very much. Item 4. Consideration of 2 instruments that are not subject to parliamentary procedure. The first is the Act of Adherent Rules of Court of Session Amendment No. 5, Miscellaneous 2013, SSI 2013-238. This instrument makes a number of amendments to the Court of Session rules. The DPLR Committee has drawn the Parliament's attention to this instrument on the ground there appears to be doubt whether the instrument is inter vires and there is a minor drafting error. The Lord President's private office has undertaken to rectify these matters promptly by laying an amending instrument. Do members have any comments on this instrument, or are you content to note the instrument endorse the DPLR Committee's concerns? Content. The second instrument is the Scottish Civil Justice Council and Criminal Legal Assistance Act 2013, Commencement No. 2, Order 2013, SSI 2013-262. I get paid for speaking quick. The DPLR Committee agreed to draw this instrument to the attention of the Parliament on the ground that it is defective, as it brings Section 20 of the 2013 Act into force when that was not the policy intention. The Scottish Government has brought forward another instrument, you'll be pleased to know, SSI 2013-271, to correct this defect before it comes into force. I'm looking at you, Margaret. Do members have any comments on this instrument?
Yes, again, content to note with the comment that this is statutory 271. There's over 300 orders a year. So I think the Scottish Government really has to put sufficient resources into the drafting to get it right first time. And if they don't do that, then they're spending valuable time and resources correcting mistakes.
Yeah. I think that's on the record now. We don't need to write to them about it. They now know that there's many drafting errors coming on. We now move into private session. And